Item number 47, we have filed an affidavit yesterday, my lord, to bring on the records of the instruction, my lord. My lord, affidavit may be called for, my lord. Today's urgency is there, my lord.
47.
47, my lord.
Get the evidence.
May I please, Your Lordship? Lord, item, my lord, 39, my lord. Kindly, my lord, after vacation, my lord.
Item 39 is the request of the council agent.
Madam, victim answer item number 8, madam. The husband side has filed affidavit, madam. I have to file affidavit in reply, madam. After vacation.
Hold on, council. Petitioner 24 is granted right to file. Beyond the affidavit file. Please start.
May I, Lordship?
Deep
Lordship, item number 24. Lordship, may the item may be passable for a day.
Item 24, part today as a request of the council.
Maybe sir, item number 33 may adjourn this matter after a vacation.
Item
33.
33. It's a by order matter.
Yes,
33.
33.
It's a by order matter.
But Lordship, Miss Kapukon is out of station due to some medical reason.
It's for the petitioner or respondent.
Respondent.
You are mentioning for respondent.
Yes, Lordship.
Have you taken consent?
Consent, yes, Lordship.
Yes, no objection, ma'am.
No objection.
No.
If you mentioned it by order. Item 33, a joint request matter. Agenda 3.
Apply.
Your Lordship, I beg to mention a WPC for listing, which is a pension matter. Your Lordship,
Fresh
actually,
matter?
my husband.
Pending matter.
Yes,
Pending matter.
yes, Your Lordship. Kindly fix it on 24 to 2024. After review,
26.
Your
26.
Lordship, any date other than 23 and 26.
That's 29.
Much of it.
May I please, Your Lordship? My lord, yesterday I have filed an additional affidavit in connection to item number 43, my lord.
Have you served copies?
My lord, I have, sir. My lord, it may be called for, my lord.
43.
43, my lord. Some recent development has taken place, my lord. There is a status quo order, my lord.
You are for the respondent.
I am for the petitioner, my lord.
Petition.
Fine.
Okay, 43.
Obliged, my lord. Highly obliged.
My lord, as regards item number 44 and 45, probably your lordship has a long list today. It's a hearing and
Always a long list.
Your Lordship, the item may be taken up for disposal today at 2, maybe, Your Lordship. If Your Lordship may allow. For disposal, Your Lordship.
otherwise, I had a talk with Mr. Mahanta. We have nothing more to submit except some queries that regarding what benefits they will get. I have got the instructions, what benefits they will get upon the imposition of that penalty of compulsory retirement. I have written a short note on that. If my friend agrees, then I'll submit it. Otherwise, no further hearing is required, I think. Or else will at 2 it may be taken up.
Your Lordship.
All right. Then.
Obliged, friend.
Thank you, Your Lordship.
May I praise the Lordship? Lordship, here the challenge is to two conditions which were imposed in the order of provincialization. Lordship, the item number 1, your Lordship will find the provincialization order at page 20. Lordship, all are similar. In all the cases, the same conditions have been challenged. Page 20 is the order, Lordship. May I read?
23.
Page 20, Lordship, 20.
Yeah.
May I read it, Lordship? In pursuance of letter dated so and so, and in accordance with the provisions contained in the Assam Education and Provincial Services Act of 2017 as amended in 2018, the governor of Assam is pleased to provincialize the services of the teachers, tutors, and non-teaching staff of Maheshwar High School District, Borpeta, with effect from 1st of August 2021, subject to the condition that their performance and number of students in the HSLC 2021 conform to the eligible standards. We are aggrieved by this imposition of the condition that it will be effective from 1st of August 2021 and that the provincialization will be subject to our performance in HSLC 2021. If your Lordship kindly takes up the act for a moment.
Notice very.
Yes. page
Your
number-
Lordship, kindly turn to page 109. 109, Lordship. Lordship, it's
2017.
2017, Lordship.
Ah.
Page 109, Lordship. Section 3, subsection 6, Lordship. Page 109 at the bottom, Lordship. In case of a venture high school or a venture higher secondary school or a venture junior college or a venture degree college, the concerned venture education institution must have a consistent good academic performance, which would mean that at least 30% of the candidates appearing for the final examination as a whole must have passed in the last 3 consecutive examinations held during the previous 3 consecutive years prior to the date of coming into force of this act.
So first tell us,
Lordship.
what was your status? Were you working earlier? You're
Lordship.
working
Lordship, I was working
as what?
Lordship, it was a venture high school.
Venture.
Lordship. Lordship, it was provincialized in 2021 under the Act of 2017.
Right.
Now, Lordship, clause section 3(6).
When was it provincialized?
Lordship, it was provincialized on 3rd of January 2000. I'm sorry, Lordship. 4th of January 2021 with effect from 1st of August 2021. Lordship, our submission is that, Lordship, under section 3(6), the education requirement is for the previous 3 years prior to coming into effect of the act. Therefore, it would mean 2014, 15, and 16. This condition that our provincialization will be subject to 2021 is over and above the stipulations contained in the act. And as regards, Lordship, the date of effect from 1st August 2021, section 4 also specifies. Section 4, Lordship, page 114.
Yeah.
Section 4, Lordship, subject to fulfillment of all other provisions of this act, the services of the teachers and/or tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette. Now, this order having been published on 4th of January, making it with effect from 4th of August, is again against the condition prescribed herein. Now, Lordship, a similar issue, exactly the same issue, had come up before another bench of this honorable court, and an order has been passed whereby these conditions have been set aside. Exactly same condition. If I may place that order, Lordship.
Any copy? Copy has
The Lordship will kindly see the second paragraph, page 2, as projected in the writ petition. The second page, Lordship.
Yes.
Second page, Lordship.
Second page.
Lordship, page 2.
Yes.
The grievance raised in the present proceedings by the petitioner is with regard to non-release of their salaries with effect from September 2021. Although their services were provincialized by the order dated 4/1/2021 with effect from 1/8/2021. Same is our case, Lordship.
Then
Now,
what happened?
Lordship, now after going through the factual metrics, the court arrived at a finding that the page 5, in view of the conclusions, the stipulation with regard to date of coming into effect of the provincialization of the services of the petitioners, that is 1/8/2001, and the condition that their such provincialization is dependent upon the performance and number of students in HSLC examination 2021 stands set aside and quashed. The petitioners would be deemed to have been provincialized in their services with effect from 4/1/2021. Accordingly, the petitioners would now be entitled to receive their pay against the post of tutors with effect from 4/1/2021. And accordingly, the director was directed to release the petitioners their pay with effect from 4/1/2021 as tutors within a prescribed time limit. court have taken into consideration clause 316 as well as section 4. To state that these conditions are over and above the prescriptions of the act.
Yes,
Yes, Madam. I just want to go through the order written up in my learned friend, my lord.
but why this was allowed, why this was interfered, with all respect. No, I'll have to go through it again. It doesn't appear to have been discussed, other than the fact that this was the mandate of the act there.
Lordship, yes.
Now, your provincialization will be with effect from the date is notified.
Lordship, it is notified.
That is provincialization of the school.
Lordship,
The school has been provincialized with effect from 3-1,
3-1, 4-1, Lordship,
4-1,
Lordship.
whatever it.
Lordship.
Now, does it automatically mean that even the teachers will have to be provincialized with
Lordship,
effect from that day?
Lordship,
Why was August chosen? Why?
Lordship, if I may read it once again. Subject to fulfillment of other conditions of this act, the services of the teachers and or tutors of all venture education eligible under section 3 shall be deemed to have been provincialized. So the services of the teachers shall be deemed to be provincialized with effect from the date it was published. Says Lordship, the services of the teachers and or tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notice. So the services will be deemed to have been provincialized.
Why was why was it provincialized on August?
They haven't filed
Any particular reason for
That I have to open instruction, madam. My lord may issue notice and
no issue notice? Go through it. Because it says it is a covered matter. It says this issues are covered. So
and the petitioners are Lordship serving without salary from September 2021, 2.5 years without salary.
Huh?
2.5 years they are serving without salaries. Lordship, in April 2023, an order was passed to release us our salaries. That has also not been done. They have filed a contempt that is pending. So for 2.5 years they are serving without salaries. In all the cases, sir. And Leonard may go through the order, Lordship, because Lordship may take it up after some time.
Not after the. Because it will cover up all the matters
Lordship, yes.
after 1 week.
Lordship,
It will
Ob-
be taken up after.
Complaint, Lordship.
Lordship, may I pray for a fixed date because they are working without salary for a long time.
It will up on 22nd.
Lordship, oblige, sir.
Mumbai. Okay. Mumbai. Conclusion diploma, যে কোনো একটা দিলাম। Well, there are similar cases are pending, my lord. And similar cases are pending, and I have already filed affidavit in this case, my lord. This matter we take along with petition number 6916
How
2023.
many cases are pending?
There are 4-5 cases. I can recall only one case where I have filed my affidavit, my
What is
lord.
the issue?
This is, they want the pension.
My lord,
They have to consider pension for that. They are appointed in 2022. They want. Now should turn to page number 30 as teacher.
You're appointed as teacher.
I'm a teacher.
Now they're praying before the court.
All getting the pension, my lord. As per old act, my lord. 1969 act.
After pending. Okay.
6976 2023.
976.
My lord, I cannot recall, my lord. In this matter, my lord, I have filed my affidavit. No, my lord, I can't.
In 6976, are they connected or it has sorted out?
My lord. Similar, exactly similar, my lord, and that.
The other cases, are they connected to 6976?
Yes, yes, my lord. Absolutely.
Ending is 976.
76 or 2023.
Twenty-fifth. 25th.
Yes.
oblige. Please, Lordship. Lordship, this matter may be listed along with this, Lordship, I have filed another writ petition, Lordship, on yesterday, Lordship. That is the serial number, Lordship, 4288 of 2024, Lordship.
For what purpose?
Lordship, on receipt of the notice, Lordship, on 18 December 2019, Lordship, on 19 December 2019, dismissed from service, Lordship. For that, Lordship, I am challenging this,
And what have you challenged here?
yeah, Lordship, on suspension order, Lordship.
So this has become infractor now.
Lordship, that matter maybe, Lordship, infractors, Lordship, that's, Lordship,
Become infractor. You get the other matter listed. You have been dismissed from service.
yes, Lordship.
So where is the question?
Lordship, Lordship, here,
You are appearing for the bank.
Yes, Lord. It's a private bank, Lord. Whether it is available to the
Lordship, along with this street petition, Lordship, along with this street petition, Lordship. This matter may,
Find another.
yes, Lordship.
You have infractor that they
No, Lordship, in fact,
heard
Lordship.
direct counsel. It's submitted that the petition is fine. It should go straight for setting. Uh, 10 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 It's submitted by the letter of in time. Okay. This property. Therefore, subject matter part. That we are
D-board वाला,
D-board.
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 मतलब
Yes.
Madam, this matter, madam, she was under transfer from Guwahati to Barpeta, madam. So lastly, madam, she was attached to Guwahati office, my lord, till she improves her health. Madam, now, madam, I've been told that she is under pregnancy, my lord, and she is on leave. Because she was getting treatment here in Guwahati, my lord.
What is to be done?
Let it be come after a month, my lord.
You are enjoying the stay order.
No, not stay with this. Otherwise, she is also attached to Guwahati. Lordship may say page 87, my lord.
Who is for the respondent?
Respondent, madam, health is there, madam. The 87, page 19, my lord. Oh, sorry, NHN 19. She was transferred within after 2 years, my lord, because although there is, I mean, normally the person are transferred after 3 years, my lord. Wait,
So she is attached.
please attach.
कोई
Pregnant? Pregnant or sorry.
बोल ना ना बोल जे मना आपने
Now, yes.
So let it come after a month, my lord.
that part may be recorded man
What?
after 1 month मतलब in that case there is transfer order I suppose
Transfer.
No. You are praying for a day of the operation of which order?
Yes. Their affidavit, they filed the affidavit also, my lord.
No, you are praying for
Stay-
the
stay
stay of the
put, stay
operation of page 87.
Yes, ma'am. Yes.
But 87 has permitted you
To stay in Guwahati,
to
madam.
stay in Guwahati. So why are you telling it?
But she was transferred, my lord, to Guwahati office, my lord, director and the director in health.
But then it was modified.
Let it come under my 22nd, I'll take inspection, my lord.
And then-
But let it 24th, my lord. Let 24th, my lord.
yes
Because I think it has become infractuous.
Let me see, my lord. 24th. 24th, my lord. Abel.
Our primary basic view is that it has.
Yes,
become
yes, yes.
infractuous.
But actually, she is benefited with this order, my
You
lord.
want a deeper. April. Okay.
inspection was called for
My lord has dealt with a similar matter in the past. My lord, have a copy if you can consider it. He seeks the benefit of the Upen Das's judgment, being a casual worker.
Yeah. Give him a copy.
Or given a copy.
yes sir.
Covered case.
Yes. Let them examine first, the third. Yes.
My lord, by this petition, we prayed for our subsistence allowance to be released. Arrear as well as current. Arrear they have released, my lord, Lordship may close the matter by directing them to pay the current.
Third council submitted by the law. The subsistence allowance along with the area have been released. There is no further report. The all.
One input.
Deeply.
I am for three women.
Yeah.
Okay.
Yes.
Lordship, affidavit is for vetting, Lordship. The director of the concerned department is already transferred to Dalguri as district commissioner, so we need 2 weeks' time. However, in the meantime, one instruction is there, Lordship, that the file has already been forwarded to AG, Lordship. But I'm not sure as I have no document relating
I
to
have
that.
also got some instruction, my lord. AG already released the pension to the treasury. In treasury, my lord, petitioner's name, my lord, Odanta Rai, and he submitted PAN card and bank account. Here, my lord, written as Odanta Devi. That's why, my lord, there is some confusion. Immediately, that would be rectified, my lord. Already affidavit has been submitted before the treasury, my lord. My lord.
It can be closed.
My lord, I may not be closed, my lord. After 2 weeks, my lord, I will take instruction more, my lord.
No, but you say AG has already released. AG has released.
AG has released, now pending before treasury, my lord. Let it be come after 2 weeks, my lord.
Family pension,
My lord, pension dues.
pension or family pension?
Family
Family
pension.
pension.
My lord. Obliged, my lord.
29, my lord, I have some difficulty in 29, Lordship, it may be on third.
Third.
No, Lordship, I'm not available till second, Lordship,
All right, third.
third, Lordship. Obliged.
Obliged. Okay.
Matter list non the family pension of the petitioner, my lord. And last of them, my lord, some instruction was produced by the government, my lord, and they were asked to file affidavit.
Lord, as such, the case of the petitioner is covered by the Provincialization Act 1999. The directions may be given to the commissioner to process his pension papers and accordingly forward it to the director pension. Because he was appointed in 1960 and retired in 1992. So his case is anyways covered by the Fazle Rabbi's judgment as well. As such, his wife is entitled to be disposed of.
There is no dispute with regard to the service period.
Well, that the commissioner can verify the entire service records and accordingly process and forward it to the director
On last
pension.
of them, my lord, on last of them, my lord.
We close the matter.
We'll dispose it of today.
Examine the as far as the process your pension paper, subject to verification.
Malot, on last way, they produced an instruction saying that commission has already forwarded the papers to the Malot.
Very nice. Third learning council. We might want to read. Applicant. Due to her. Eight hundred. How much time? Perfect. Was appointed as council. 38 will I. And after for about 30 years. It has read. Please look in my. The and the type of break to scale okay type of same service review service. It has filed one level of after filing the further for this case that the effect of the effect of the effectively the employees are like and effective as treated based on the all employees. making it for direct department. Okay, keep up, keep up to that. Keep up. It, but it serve the the expect. The date for every- every- with the night. Then, date, 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 49, pension, date, or date, that, prepare that, date, date, that, date, the period, time, like, in a 3 days, like, the single, right, again, right, meeting, like, that,
Pension.
and the department, right,
बोला
well, it unappears, unappears for the,
My lord, otherwise, my lord may issue notice in this matter.
let them come. They're stipendary teacher.
Yes, my lord.
So
I
why
have-
issue notice, we can close it.
No, my lord. It's regarding my lord, illegal, irregular, my lord. Subsequently, my lord, some of them have been accommodated.
Let them come.
Yes, my lord.
None appears for the petitioner on board with the Dante Petunier, appears for the education department, and Evans, Bourbon board. That's not fine.
Obligation.
May I please your worship? Your worship, last week was directing the government to place the instruction. Worship.
Lordship, there's no representation in this petition.
Huh?
There's no representation in this petition. Perhaps the matter can be disposed by asking them to place a representation. It will be disposed in 30 days, Lordship.
Our names also been forwarded, Lordship, last.
Because
Page
as such,
52,
Lordship,
all the
representation is
names
not
they-
there in the petition. Lord.
In terms of letter dated, Lordship, 30, even though 21 may be disposed of. Yeah, letter,
Have you,
Lordship.
Barney, have you approached the authorities?
Yes, Lordship,
Where?
appeals the authority.
Where?
Yes, Lordship. Kindly see the page 52, Lordship, page 52.
Yes.
After approaching them, Lordship, they forwarded our name, Lordship.
This is a letter by DFO, Lordship.
Yes, our names forwarded, Lordship, because of approaching, Lordship.
Forwarded to whom? Principal?
Yes, Lordship. Forwarded to Principal Conservator Forest, Head of Office.
Then,
Then no steps has been taken. Then Lordship, page 71, government made a query why their names not been considered, then page 71, Lordship. Annex 8.
Yes, your instructions are not what to do.
They may be asked to give a representation, Lordship,
What
because
representation? Why do they want a representation? Your department is already accepting their cases and forwarding it.
but for his particular case, Lordship, some
Why?
verification has to be done if they are serving for 10 years or not.
Kindly go to the petition, the annexure. Annexure number 871 is the letter of the Joint Secretary of the Environment and Forest.
But Lordship, it is not clear who it is referring to, Lordship. That is why representations are required. The petitioner may give a representation, Lordship, with all the qualifications and everything, because this is not clear, Lordship, who it is referring to, missing out workers.
No, this is in terms, this is with reference to there are references given here.
Here, the references, Lordship, about minimum pay scale as per Open Dance. But Lordship, in order to verify that, a representation has to be given, Lordship.
Where is that? Where are these communication at page 71?
71 losses,
Reference, communication shown with the reference.
yeah, 8, 12, 21.
Where is it?
That is not available to me, Lordship.
In respect of
But-
whom?
Lordship,
In respect of whom the application was forwarded?
page 71.
Yes.
Petitioner's Lordship,
How do you say it?
Lordship, kindly see the page 52. 30, 11 to 21.
Where is the reference of 3011? Page 71.
71, that is not referred, but place 52 may kindly be looking to.
So then why are you referring to 71? It doesn't concern you.
But paragraph may, your Lordship may.
You are trying to show that
Paragraph, yes,
71,
Lordship,
71 also concerns you.
yes,
There is no reference.
yes,
So
my
the
statement is there in paragraph 10.
statement is irrelevant.
You know, Lordship, in terms of this letter,
In terms of which letter?
earlier communications Lordship. Paragraph 10, Lordship. All the persons' names earlier also forwarded.
No, this is as per 3011. Paragraph 10 is a
After
statement.
verifications, Lordship, our name be forwarded. My learned friend says that whether you are qualified or not, whether you have completed 10 years, that is our details of, I also, detailed statements given Lordship in chart 1, page 22. And they have already been forwarded. We have completed more than 10 years.
So, page 51.
Page 51 is similarly situated persons, they have been allowed Lordship. Page 51.
You are referring to which page earlier?
Lordship. Page 29 may kindly be looked into. First forwarded our name. Page 29, that letter is 23/7, 2018.
Minute, 1 minute. You are referring to page 63.
Page 63,
This contains your name.
yes, Lordship.
You don't know.
Page 63 is the type of, yes, original copy, yes, page 63, Lordship. Annexure 7. Type copy is 52, start from. Our names are also included.
You get your instructions on page 63. Tell us what is the status.
I'll get instructions.
Details of all the petitions named.
Learned Council for the Forest permitted to obtain instructions with regard to the communication dated 30/11/2021. Annexure 7 page by the Divisional Forest Officer, Eastern Assam Wildlife Division, Bokanga. So in terms of this communication, the status of the casual workers who are working for more than last 10 years in Casino Metro Park. It is the submission of the learned counsel for the petition that this communication dated 30/11/2021 includes the names of all the referees. Learned counsel for the forest will therefore apprise the court as to what steps have been taken by the forest department to grant fixed pay.
Fixed pay.
Fixed pay
Yes.
in terms of Penda. Get readability to the writ petition. These instructions will be placed before the court by the next meeting based on 29 April. Anyone appearing? Yeah, for forest. Sorry, finance. Are you there?
No, can I make a mention? Item 13, my lord, your lordship wanted AG, my lord. I was supposed to be there, I couldn't be there.
Item
13, 1-3.
13. You did not want to.
I was supposed to be there, I couldn't be there.
Are you a party there in item?
I'm for the AG, my lord.
Okay, report your name.
All right, all right.
Item 13, Mr. D. Bhattacharya. Okay. Yes, you'll consider their cases.
No, not consider. Lordship directed me to obtain instruction, whether similar benefit were given to others also, Lordship.
Yeah.
That's it.
So what is the
Lordship, here they are relying on 4 cases. So my instruction is that 3 names were erroneously recorded, but actually they have not given any benefit. But erroneously, their name was included in the that list that they were relying on, Lordship. And then we rectified that and directed them to go to their place of posting, which was fixed by the year 2023 itself, Lordship. And for another one, Sarveshwar Das, that he had applied under special categories that is already mentioned there, and his case was considered for that reason, Lordship. Lordship may kindly see page, second page. That.
Yes.
Second page, Lordship. That these are the criteria, clause 3, Lordship, and under that clause 4, 3, 4, working couple. Under that criteria, Sarveshwar Das had applied before issuing of this revised guideline.
What is the meaning of working couple?
Working couple, both are husband and wife, both are working, Lordship. And his wife, that is also we have given, not in railway, but he is a school teacher. And on that ground, he submitted a representation and his case was considered, Lordship. In view of the above, application were invited from RPF personnel who made the criteria mentioned above. Subsequently, thorough scrutiny was conducted and only eligible RPF staff were transferred according to their preferences. Sarveshwar Das head constable is come under the above criteria number 4. It is reiterated that this transfer on personal request ground are unrelated to the incident case filed by the petitioner so and so. So he has not transferred for 3 choices of posting, but for special reason that he had applied before the revised guideline. Guideline came on 18/3 and his case was considered on 11/3. And regarding that clause 5, Lordship, Chittaranjan Das, the last order Lordship had already recorded that we have stated that in clause 7, it is to mentioning here that the list enclosed by the petitioner in the petition is an annexure of so and so number of the post for the current year. The name of Chittaranjan Das along with other 2 so and so are mentioned erroneously in the list, but they were already spared on 31/3/2024 to carry out their transfer order. So names were wrongly included. but no, this option was not given to them. They have already spared. And out of the personnel who were transferred, most have already joined their place of posting,
What
Lordship.
is the meaning of why have you spared him?
Lordship.
Why this person was spared?
After the transfer order, they were spared, Lordship. Spared order received.
Spared him?
10 days, they were given 10 days of transfer and then they have to join. And they are now not in here, Lordship.
No, you have to clause 6.
Lordship.
6, Chittaranjan Das and 2 others were
Yes.
erroneously mentioned,
Yes,
but they are already spared
yes.
to carry out.
That Lordship additional affidavit, they have included one list. There they stated that these 3 persons, although transferred in the year 2023, but they were given option of 3 choice of posting. But our case is that their names were in this list wrongly included, but actually they were they have not given the benefit and they were spared as per the earlier transfer order. So no injustice has been caused to them, and it's all are equally.
Yes, ma'am. Right now, I have received another letter, Miller. Another person has been considered, was transferred.
This is never ending. You
If-
consider their cases.
Now I am afraid, Miller.
You
Again, they
consider-
will cancel it.
And whatever benefit it will make, attributable to them, we give them.
Lordship.
Not.
But stay order, because Lordship, that will be difficult. We have to this, because that
Do it immediately. Who's asking you to do it after one? Do it 48 hours, 72 hours.
because that transfer order of 2023, they have also know that they have to go by 20
Now he is coming up with another letter saying that another person has been given that benefit.
that is not in the writ petition. Writ petition, they come up with one stand, we have given our reply. Now they will again come, this cannot be Lordship.
But there is some information which has come with me. He will be right to be court that we accept or not. But if it basic case is arbitrary, and you have given some benefit to similar person like me, you are denying me that.
That we have stated that no, this is not done.
Even some examples again. Now, suppose let us say that he come up with one more example. Your instruction should contain no list of all the persons who may or may not have been given the benefit.
That is why only 3 names were wrongly included. That we have stated.
Something else.
But 3 choice of posting, that is not in the previous
It
order.
was in the previous directive also.
Let us, well,
Because Lordship, in that case, their earlier prayer is only to that annexer.
Exempt.
That was not in their earlier writ petition. And so the order remains, Lordship. Their only ground in that the educational region of their children.
54.
17,
54.
54. This is the earlier directive.
Yes, where is it?
Second terminal. Page 54,
54 or 64?
54.
54. 54 contains Roman 17.
17.
Ah.
All the officer staffs under zone of consideration for transfer, we have to submit, will have to submit option of all units where they are eligible to be posted in descending order of choices. It was earlier also this option, what was there. And then
It has to be there. Choices.
But that time they have not availed that in filing writ petition. Their only case at that time that they need time up to 31/3/2024 because of the academic reason of their children. And now that was considered and that because
Where is the earlier order?
Earlier order is the case. Your Lordship, can you see page 34? 34. It was not decided on merit, my lord. Relevant portion, para 12, page 36.
Your prayer before the court earlier was that you had children studying from class 1 to 12
Yes.
in different and subsequently there was an extension granted and therefore
Exemption. Exemption
exemption for effective
for all
1
the
year
tenure transfer, my lord.
till
Not
31st July. So in that context, the court said that your prayers have become infructuous.
and that's why it became infructuous without deciding it on merit.
But
And the benefit was up
the-
to
no,
31st
that-
March 2024.
the transfer order has not become
Yes.
infructuous.
In view of the exemption order, my lord.
No, exemption is till that particular time. You're not exempted from transfer. You're exempted.
No, not exempted from transfer. In view of this exemption order, my lord, the transfer order has also become infructuous.
No, how?
Because
Up
Your
to
Lordship,
31/3/24
up to
only.
31st March, I will hold the post in my original post, my lord, because of this exemption order, and that's why the writ petition has become infructuous. So I will get the benefit in the meanwhile if anything has come. The new revised directive has come.
You were transferred.
Yes, ma'am.
And you were supposed to join.
Yes, ma'am.
Instead, you came to the court saying that we want certain accommodation because our children are studying so class
Yes,
1
yes,
to 12.
yes.
Then there was an exemption. That they have granted one-time exemption for completion of periodical transfer. For completion,
Yes,
means you have to go and join in that new place of posting.
yes.
So that was given till 31st of July in place of 30th of June.
Yes, my lord.
And the date of start of your tenure will be deemed to be from 31st of March only.
Yes. Yes. Now what they have done, Miller, there it is the discriminatory action of the respondent authority. Some people are they have considered a case of some other person, Miller, while not considering our case.
No. Are those people similarly situated?
Similarly situated.
Listen to them. Are those people similarly situated in the sense that they were also covered by similar transfer order?
Yes, Miller.
What?
Yes.
What?
Into now.
I afraid again they will cancel this order. Tomorrow they will come another order.
What is this order?
23, your lordship. Serial number 23.
Serial 23. Yes. What does it say?
Project was short form.
No, I'm not on that. See, you were given a transfer order. What was your date of transfer? What
Date
was
of
the transfer
transfer
order?
27, 21/7/2023. He was also transferred. This serial number 23.
It was transferred by which order?
By an order dated 27, annexure 23, relevant portion page 24, serial number 42.
You're referring to which document? This one?
No, Miller, my read petition. The transfer order,
Yes.
page 24.
Page 24. 24.
Annexure 1,
Yes, 24.
post order number 24.
Yes.
Page 24, serial number 43, the last one.
52. Serial number?
No, 52, no, 42.
42.
42.
42 person is that serial number?
Ramesh Chandra Roy, and in this order, Miller, his
Is
name
that
is
serial 23?
20.
Lordship, then some facts are not clear, Lordship. Ramesh Chandra Rai was actually,
No. Let us make it clear. You bring whatever one you want to bring it on by way of an additional affidavit. Whatever you want to bring in.
Yes, Miller. Earlier also we have brought some documents.
Whatever documents you want to bring in.
Earlier we have filed
Earlier also you bring it together in an additional affidavit.
we have already filed one petition, but now they have come with another order that they have cancelled it.
Ramesh
And right now we have received this one.
So you bring it on.
Yes, Miller, I will.
Lordship, they are enjoying. Lordship, Ramesh Chandra Rai had also filed a writ petition, and his case was also disposed in the same date, Lordship. That fact was not placed here, Lordship. By the same order, Lordship, that Lordship had already read, Lordship, the same order, his case was also considered. I can bring the,
So that's all right, but then you have given him the benefit.
his case was a different one. His criminal case was pending against him. So that view of the matter, he was spared, and he was, that case.
See, you are taking two steps. One is that once an order is issued and the completion of the transfer order was given a one-time exemption, and whoever had filed a writ petition, those writ petitions became were rendered infructuous on the ground that the exemption was granted,
Lordship.
would mean that the transfer order remained. Transfer order which was challenged remained, isn't it?
Lordship.
Now, if that is so, then in pursuant to the new directives, how can you now consider the cases?
But Lordship, difficulty is that they are coming with one by one order, Lordship. That whether Ramesh Chandra Rai's name is in this list, Lordship.
It is within your rights to publish
Even if
to
the-
give a list complete, and all the personnel who are being considered are learned counsel for the parties.
42
They
নহয়
had to be listed here
দিও দেখুৱাই দিও
on 30.
এখন নহয় এখন
Anything
আপুনি
the learned counsel for the petitioner on record. The additional.
Even I have not given the copy also, Lordship. Extra copy also not of this document is also not given.
Bring it, you file additional affidavit, give it to her.
Yes,
By give it to her by tomorrow.
yes.
Let the matter be listed again on 30 April.
So Lordship, whether his name is included in the list that he is Annexa 103 and 104, that has to be Lordship. Because according to them, this is
I didn't get it, sorry.
Lordship, according to them, that name of Sitaranjan Das was included in page number 103, 104 at clause number 17, additional affidavit, Lordship. So where Ramesh Chandra Das name is also there.
No, Miller.
No, if not, Lordship, how can they say that the benefit were given?
No, we are asking him to bring it on record.
They are enjoying 17%,
Maybe
Lordship.
they are enjoying, but if they have a case, let them bring it on record so that we can finish it off instead of doing it in piecemeal. It is causing difficulty for you also.
Causing difficulties, but once they are taking benefit and that time,
It's only an interim order. If we vacate the interim order, it goes back to the date. The order
but,
of transfer, that's all.
piecemeal basis, they are placing one
That's right.
document is another document, Lordship.
Exactly. So therefore, we are giving them one final opportunity to bring it on record.
Lordship.
Whatever you want to file, whatever documents, what instructions you want, bring it on record by 29th and 30th, we are taking it. 30th of April. That will be listed again on 30th of April, enabling the Joint Council to the additional affidavit. File the additional affidavit to bring on record additional documents which is submitted are necessary for effective disposal of the determination. Let copies of any such additional affidavit filed are on the third and council on the respondent by 26. Yes, by 26th of April, you serve, matter will be listed on that.
Miller, only one submission. In the meantime, we may be allowed to work in the present place of posting
They are,
because they are not,
already spared before
they are
the,
not allowing us.
An interim order.
Yes, Miller, even then, Miller, they are not
they
allowing
are
us.
already spared before the interim order. So now,
Miller.
You enjoy the view at
Yes. Obliged, Miller.
the interim order passed earlier, we continue to the date fixed. But we are making it clear, please serve copies by 26.
Yes, sir.
Yes. Suspension.
May it please your lordship. It's a matter pertains to the statutory subsistence allowance, your lordship. And there is an impugn order at page 57, your lordship, as annexure 11.
Yes.
Then after that, I have given my detailed representation that I have annexed at.
Have you not been paid your subsistence allowance?
Yes, your lordship. So it is departmental proceeding is pending.
Yeah, let them get notice, instructions there, who's there? Yes, sir. Why subsistence allowance has not been paid?
Yes, ma'am, I'll open instruction.
I'll turn it out. Department. Department of the petition, right. In spite of the case after suspension. ID. The order. Page number? What is the order?
At page 57, your lordship, annexure 11.
ID the order. Dated 22/11/2023. Suspension. Pending royal office department. It's submitted that her subsistence allowance payable to the
There is another, your lordship, there is another aspect of this petition. The entire issue has been pending before the education tribunal. It is sub judice before the tribunal and it is in the trial stage.
which issue?
that about my existence as a lower division assistant. And these are, it is clearly stated in the impugn order. In pursuance of this honorable court's order, which I have placed at page 43, annexure 8.
You are who? You are the headmaster.
No, I'm the LDA, lower division assistant, Your Lordship, Saira Khatun.
But this is about Abdul Salam. Okay. Aira.
At this stage, Your Lordship, both of them have given, there are 3 numbers of persons against whom the suspension order was issued, and 2 of them have enjoying the subsistence allowance. Only
So you let us
it is
find
kept pending before.
You let us find out why the subsistence allowance is not returned.
Yes, madam.
Let the instructions be placed before the court. On 1st of May.
Yes, madam.
1st of May.
Obligation.
Although notices are not issued, extra copies will be till next time. Within the course of the week. It's on 1st of Yes.
May I please your lordship. My lord, in this case, though I was appointed in the year 1994, ultimately my regularization came in the year 2006. The next post facto approval was granted in the year 2008. And from 2008, I was readjusted and I'm getting my regular salary and everything. So there was a question of my arrear salary in respect of 2006 to 2008. But in the year 2023, that is last year, I got that benefit. But only the thing, my lord, during that period, the revision of pay came. So that difference is not yet paid. And by annexure 16, the DI of schools, Bongaigaon submitted the difference of that arrear in respect of the refixation, and proposal is sent to the DEO. And it is in the office of the DEO since last 2 months, my lord. Only that has to be, my lord, sent to the director. It has to be verified. If I'm entitled, I should get it. That's all.
Yes, Mr. Khat.
Yes, my lord.
Which one is to be verified?
Page 16, my lord.
Annexure 16.
Page 43, my lord.
Page 43 onwards, my lord. This is the proposal, my lord.
This is pending before DEO.
DEO. He has not forwarded to the director.
2024. Get instructed there. Learned standing down education, elementary education department will obtain instructions by proposal for sanction of the difference of areas that from 24/4/2008, 31/7/2023 in respect of the repetition. Forwarded to the office of the DIO by the DIS, Deputy Inspector DIO, has not been processed further. So, let the instructions be placed before the court. The day after the repetition next on 1st of May.
My lord,
Similar order.
Similar order over here, my lord. In the meantime, the middle school was merged with the high secondary. So, my lord, annexure 15, page 44. Over here, it is already before the DSC, my lord. Director Secondary Education, Assam.
This is pending before Director Secondary.
Yes, my lord. He has to verify and finalize it, my lord. Page 44, my lord.
44. So why two different modes? One by the DIS to DEO.
No, that is because elementary and this is secondary.
Okay. If the instructions to be furnished as to why the arrear proposal, a proposal for arrears and slash DA, like suspension allowance, slash pre-fixation of pay, like MSCPS and leave salary pertaining to the teachers of the Vivekananda, pertaining to the staff of the Vivekananda higher secondary, where the writ petitioner is working as assistant teacher,
Yes, my lord.
which was submitted by the in-charge inspector of schools, Goigaon, to the office of the director secretary, has not been processed. Standing counsel of the it's again on the first.
Obligation.
In order to facilitate during the, in order to enable you to obtain the instructions, extra copies be furnished. Within 1 week, extra copies. Both the matters, huh?
Deeply obliged.
You're right. Huh?
May it please your lordship. My lord, this petitioner is under suspension from March 2023, lordships. Matter relating to leakage of question paper HSLC 2023. Lordships, at that time, altogether 11 persons were suspended, lordships. Lordships, all are reinstated except me, lordships.
Where is the suspension order?
Lordship, page 18, lordships. Page 18, order dated 22/3/2023, lordships.
Any instruction?
No, your lordship, I'll obtain the instruction.
Challenging the few order dated 23. Petitioner is the petitioner has remained under suspension, whereas other persons were placed under suspension along with the petitioner. Accordingly, stated. So, subsistence allowance,
I am getting, lordships.
petitioner is receiving. However, a departmental proceedings initiated.
Not initiated, lordships.
They submitted that departmental proceedings. According that notice be issued, the return of 4 weeks. And there are been a
1 and 2, your lordship.
what is the fee so here for 3 and 4. Steps on respondent number 5. I raised it for the usual vote.
Lordship.
Let the matter be instead again after the internal date. The standing council will serve with extra copies of the writ petition.
Hello.
May I please your lordship? My lord, this matter regarding non-payment of area salary matter. Some, my lord, similar matter is pending, my lord. Where my lord notice is issued.
Where? What is
My
the
lord,
number?
page 94, my lord, relevant portion.
94.
Yes, my lord.
All these matters are pending.
Yes, my lord. My lord, in their
The petitioner is agreed by non-release of their arrear salary.
from 1/11/2020.
1/11/2020 till February.
Yes, ma'am.
February 2023.
Yes.
It is submitted that similarly are pending before the report filed by other similarly situated parties. Submitted that the report existed along with the PPT part of it 5 and other connected. There are Mr. N. J. Here the notice on behalf of the let them along with the PPT, so and so, other connected entities. When are these matters big?
My lord, this is as such not fixed, my lord. It is made eternal,
Extra copies be served
my lord.
within 1 hour.
Apply.
Please, Your Lordship. Lordship, matter pertains to the family pension, Your Lordship. A petitioner's husband was a ACB employee and he retired on 31st/12/2000. Lordship, thereafter he was getting monthly salary regular. Your Lordship will find I have annexed the bank statement here. Page 22, annex of 5. The last amount of the pension was at page 22C. That is on 2nd November 2022. 25,700 he was getting regularly, but unfortunately he died. He died on Lordship 3rd December 2022. Thereafter, Lordship petitioner approached before the competent authority for the family pension, but she has been denied. That way, 1 year, 5 months have been gone by. So thereafter, Your Lordship, page 28, a petitioner filed a representation before the competent authority for sanctioning the family pension. But till today, they have not turned on to sanction the
Yes.
family pension, and she's
I'll
being
take
kept.
notice.
Third one. The petition is filed by claiming family pension payable on account of the services rendered by her late husband, Joe Bihari, who was an employee of the erstwhile ASC, presently APDCM. The late husband of the petitioner was rendered service and renovated on 31/12/2000. From person thereto, he was receiving his monthly pension regularly, and he fell ill and subsequently expired on 3/12/2020. So, pursuant to the demise of the late husband, of her husband, petitioner, although had approached the authority, family pension authority, whereas Mr. Porter, I mean, APDCA, I took it matter. First of May, by which day he's standing up, right, vote at 5. The petitioner document. After the petitioner will furnish extra copies of the writ petition within 1 week from today, enabling him to obtain.
It's for instruction, Your Lord.
Yes. For
Obliged.
Yes, Mr. Bhuya.
My lord. My lord, matter relates to, my lord, non-payment of, my lord, it is a case of, my lord, wrong calculation of the arrear salary. My lord, what has happened, my lord, the petitioner was transferred as a DTO, my lord, district transport officer from Karimganj to Guwahati. But my lord, instead of his joining at that relevant period of time, he preferred a writ petition challenging his initial transfer. My lord. And this honorable court, my lord, without interfering with the transfer order, asked the petitioner to prefer a representation before the authority concerned, and the authority will decide. And my lord, and in that manner, though he preferred the representation, but the authority was sitting silent. My lord. Accordingly, my lord, in that manner, the matter transferred more than a year. They did not took any decision, and I have not been allowed to join in Guwahati or in Karimganj. I was hanging. Now, my lord, at page 48.
Yes.
My lord, this is a modification of my transfer order, my lord, by which myself was, my lord, was transferred from, my lord, Karimganj to, my lord, District Transport Officer, Karbi Anglong. But my lord, may kindly note that here a word has been inserted as on leave. My lord, this has created the all confusion and difficulties, my lord. I have never applied for leave or no any leave application had been presented, my lord. Now, my lord, as a result, my lord, could not join at that relevant period of time.
You did not join, correct? Therefore, your
No, that is correct, my lord. But I have not presented any representation for my leave, my lord. It is their suo motu action that they have treated me as on leave, my lord. Now, that thing has been put into challenge, my lord, before this honorable court. My lord, even a departmental proceeding had also been instituted, my lord, and my lord may be pleased to find what has happened, my lord. In the meantime, I also retired from the service also, my lord. My lord, just for a moment at page 73, Annexure 12, my lord.
Yes.
My lord, here is a two repetitions was there, my lord, and which has been, my lord, disposed of and clubbed together with a common judgment and order, my lord. My lord may be pleased to find at page 77, paragraph 21, my lord. Page 77, paragraph 21, my lord. In view of this, court has no other option but to interfere with the disciplinary proceeding which has been done in violation of the mandatory provision of law. Consequently, the proceeding initiated by the communication dated 21/12/2016 is set aside. So, my lord, one relief has been provided, and in the second case, my lord, when I have challenged this on leave part, my lord has kindly turned to page 78, paragraph 28 has been taken care of, my lord. Paragraph 23, my lord. 23 at page 78, my lord. In view of the aforesaid facts and circumstances, this court, by balancing the equities, directs that so far the grievances of the petitioner is concerned with regard to reconsider the period from 10/4/2015 to 30/3/2016 to be on leave. The petitioner shall within 15 days from today submit a detailed representation to expand, withdraw the such remark and regularize the aforesaid period so that there is no impediment in getting his post-retirement benefit. The fact that the petitioner has retired in the meantime is also a relevant factor which the authorities would keep in mind while considering the representation. The representation be considered and disposed of within a period of 45 days from the date of receipt. The written instruction placed before this court by so and so shall be kept on record, my lord. Accordingly, my lord, I have made a detailed representation at page 79. Third set, my lord.
So what happened after that?
That, my lord, they have calculated, my lord, an amount which, my lord, may be pleased to find is at page 89, my lord.
Yeah.
My lord, and this is a letter addressed by the, my lord, DTO Karbi Anglong to the, my lord, Commissioner of Transport of Assam, because, my lord, my last posting was from the, my lord, Karbi Anglong, and therefrom I retired. That's why, my lord, this has been done by the DTO Karbi Anglong, my lord. Wherein, my lord, maybe can skip the few part. With reference to the subject cited above, I have the honor to inform you that the arrear pay and allowances in respect of so and so retired district transport officer was prepared on the basis of the pay slip received from the office of the principal accountant general so and so with effect from so and so, and an amount of rupees so and so of 430 only accrued to arrear for which the demand was submitted to your office for allotment of so and so dated so and so. But subsequently another pay slip was issued by the office of the principal accountant general so and so and dated so and so with effect from 9/4/2015 to 30/11/2016 along with the revision of pay with effect from so and so. Now due and arrear drawn statement salary have been prepared with effect from so and so to so and with effect from, my lord, in this part I do not have any objection from 1/10/2007 to 8/4/2015. It is correctly calculated. But, my lord, this 9/4/2015 to 30/11/2016, their calculation is not correct, my lord. They have treated me as an on, my lord, on leave, my lord. Till date, that part has not been removed. Removed, my lord. That is my grievance, my lord.
Yes.
May I submit, my lord? This matter is lordship brought by res judicata, my lord. Lordship may kindly have a look, page 78. My senior has already referred paragraph 23. May I read again, my lord? Lordship had got it, my lord? Page 23. In view of the aforesaid fact and circumstances, the court, by balancing the equities, direct that so far as the grievance of the petitioner is concerned with regard to reconsider the period from 10/4/2015 to 30/3/2016 to be on leave, the petitioner shall within 15 days from today submit a detailed representation to expunge, withdraw such remark and regularize the aforesaid period so that there is no impediment in getting his post-retirement benefits. The fact that the petitioner has retired in the meantime is also the relevant factor which the authorities would keep in mind while considering the representation. The representation be considered and disposed of within a period of 45 days from the date of receipt. The lordship may kindly have a look, page 91, annexure 16. We are considering his representation. In the meantime, he has filed a contempt case. My lord has got it, page 91, annexure 16.
Yeah.
Lordship, the order dated 25/9/2023. Ms. Y. Akhtar, learned counsel, appearing on instruction of Sri A.R. Bhuya, learned counsel for the petitioner, submit that the order dated 16/11/2021, passed in WBC number so and so, which is the subject matter of the contempt case, has been complied with. MS MD Bora, learned counsel for the respondent, submit that the order has been complied with, and in this regard has also placed before the court a copy of the speaking order dated 28/2022. The lordship, this speaking order is not under challenge.
Where is the speaking order?
This is, I have submitted before this honorable court. They have said this honorable court order has been complied with, and I have also said yes, it's been complied with, and this is the speaking order. The petitioner now have to challenge this speaking order. Otherwise, the matter is brought by res judicata.
What was his period?
Lord, 30.
Lordship, the decision, my lord, may kindly have a look the speaking order. As per views of finance department, the gap period is respected.
Period.
Period that is asking for.
Period 10/4/2015 to 6/10/2015. It is an earned leave period they have granted, and half pay leave for 176 days. Now the petitioner is getting pension, regular pension, my lord.
What remain?
My lord.
What remain?
No, my lord, that the leave, they cannot use the, it should be, my service should be regularized, my lord. Where is the question? That is the, my lord, finding.
Yes.
My lord, that speaking order is not with the access. I don't know how it has been escaped, my lord. So, my lord, may I pray, my lord, the matter may be taken up immediately after the.
Petitioner may withdraw this petition and file a prayer.
My lord, immediately after the vacation, I will take.
So you withdraw the
Yes.
kind of fresh word. What is there?
Yes, that can be done, my lord, because
Yes.
this speaking order is required to be challenged.
Yes, I will.
Has the counsel to the learned counsel to the decision. Liberty of the court, withdraw the writ petition and file fresh writ petition. Challenge the order dated 20/08/2022,
Lordship.
which the learned counsel to the petitioner submitted not identified at the time of filing. Remain is allowed, which is not withdrawn because as MD Bora learned.
Transport department.
Liberty to file a petition.
Deeply obliged.
Obliged.
Right, please, the lordship. There is a direction, lordship, to whether money has been released or not. Money, GPF money has been sanctioned, it was not released, lordship. I retired from service on 31/2021.
I have received the instruction from the inspector of schools that the concerned headmaster has not yet received this payment order, my lord. GPO.
How will it not receive the payment order issued on 31st of January?
Yes, my lord. In fact, I have received the written instruction from the inspector of schools. A letter was written by the headmaster of school
For the accountant general.
saying that
Sir, Borua, Please get instructions, the accountant general says we have released this amount. Okay. Earlier, Mr. S.K. mentioned the deal.
After some time,
Ah. Yes, you say the headmaster has not really received the amount, received this.
received the original copy of this GPO, my lord.
How have you sent it?
He got a WhatsApp copy from
What
some
copy?
other source, my lord.
Okay. My research was- You find out from your office and surprise us at 2 o'clock. Tell us when it was sent, how it was sent, when it was received. Find out. Let it be at 2 p.m.
Obliged. Yes, this is a writ petition lordship file claiming the arrear salary of the husband. This is husband of the petitioner. And last repeated occasions, instruction was sought for regarding availability of funds.
Yes.
We are facing some financial difficulties. Some time may gain.
This financial difficulty. You pay interest.
You
You take as much time as you want, you pay interest.
6 months, finish
Huh?
6 months time, man.
6 months.
Also, may dispose of this, man.
No. What is the amount to be paid?
That is
6,51,000.
Right?
938.
6 lakh.
Last 20 months, no salary to the employees.
Then you should wind up. Why have you not wound up? You should issue orders to wind up. You're becoming non-functional completely. And what will happen to these employees who are not receiving? Which is the parent department? What is the parent department?
Handloom textile.
Which is the handloom and textile department for appearing for that? Yes, what is wrong? Why are you not releasing the funds? Hard learned counsel for the parties. This petition is filed by the petitioner, praying for release of arrear salary payable to her deceased husband of the petitioner for the period May 2011, 17, 11, 2015. So, late husband of the petitioner, late Provincial Hormone was employee, the art fair as the branch manager in Valpara branch. The husband of the late husband of the petitioner living in lifetime approached the respondent authority for release of arrears salary for the period for May 2007, 17. But the respondent authority did not undertaken any action. Notice in the matter was issued. April 7, 2018. The respondent hardware is also filed an affidavit stating that uh, uh, stating that stating financial hardship as the cause or not receipt of salary or arrears with respect of the employees including the in the affidavit there is an averment that there is no mandatory provision for salary of the employees of the outfit taker or any financial assistance are received from the state government account of that. The revenue generated, the revenue of the outfit is generated by sale of the product to the various sales center granted immediately. That apart, the outfit has been receiving grants in aid for organized various events like Expo, by central government and state government. At present, the outfit is taking huge profit to overcome the situation management of the outfit. Representative seeking financial assistance like grant delay. The affidavit, it is stated that due to financial constraint, the petitioner's late husband had paid 20,000 towards the outstanding balance for 7,900. As per the calculation of the affidavit, total pending salary from 651,938.55 after deduction of the amount of the error. Who's appearing? The Thor. The Raj Thor. Yes, where is Mr. Thor?
He's on back on what the
Please inform him that we are disposing of the matter. Appearing on behalf of the administrative department, Department of Textile. Considering the fact that there is clear environment by the outfit that there is a potential hardship, financial constraint outfit, and proper approach and they have approached the respective, they have approached the competent department for grant of financial aid and people grants in aid. By by the applicant for release of financial benefit by bringing the tackle the issue of arrears, salary and fee and other retirement that gave the employees of apartment their husband Department of Employment Textile is submit proposal seek from the department from the outfit with regard to the amount of financial required and place it before the government at the appropriate level after state sanction state department. any such scheme that we take into consideration the financial involvement required for employees. It further declares that the scheme is framed and protected by the necessary benefit that may be offered or taken by the architect. So, for the employee, and the that the department here because also fresh proposal total financial requirement of the architect consideration of the
Okay. I would like to.
Lordship, may kindly peruse the last order.
Yes.
Director of the Finance Department.
Malab, Finance Department now on 5/4/2024, Malab, has raised some query, Malab, to the administrative department. That is the elementary education department, Malab. So now, Malab, the government has sent the query to the director, Malab. The director will furnish the information, Malab. On yesterday, government sent the queries to the director, Malab.
the finance department is doing the very by the director
On 5/4.
of elementary
Government Department of School Education, Malab. Who in turn sought the information from the director, Malab.
and this communication was received by the office director on 5/4.
Director, this communication received by the government on 5/4 and director yesterday, Malab.
The communication
I have not seen any endorsement.
We have a sign is taken.
Madam, there is no endorsement. It is letter. I have seen. No endorsement of the joint secretary.
It's a digitally signed, my lord.
But that was not it.
the council has made a statement. You verify and tell us, we pass out a recording. Don't make wild. The council has made a statement that this has been informed. Presenting it, if you think that this is not a correct document, make your inquiry.
Or my lord, they have filed the documents by way of an affidavit.
They can file it.
I'll give you a digitally signed copy, my lord.
Not request submitted to bar.
Yes, well.
What has happened to the digitally signed copy? What is this copy?
That is not reflected here. That is why.
My lord, first copy that was sent to in my number, my lord, it was not digitally signed, but later on they have sent a signed copy, my lord, and I have taken the printed out an unsigned copy, my lord. This is my mistake, my lord.
Digitally signed copy
I'll give him a copy, my lord.
by today. Today itself.
Right now, my lord, I can give.
Lordship may kindly also peruse the order dated 9/2, my lord. In spite of the order, my lord, my provisional pension has not been paid. I am suffering much difficulties, my lord.
What are the queries raised? What queries?
The queries, my lord, sanction post against which he was posted, then whether he had been drawing his self.
Earlier occasion, very years ago, they have, why should not be compensation issued upon them? That was also raised, my lord. And this honorable court also asked for a personal appearance, my lord, by order dated 8/1/24.
And what was contained in the proposal? It was said earlier.
That is the regulation of service, my lord, regarding regulation of service. That is why they have made that query, my lord, whether he was.
There was some proposal said.
Yes, my lord.
Proposal for what?
For regulation of service, my lord.
Regularization.
Yes, my lord.
So these are vital questions which should have been included in the proposal itself. What is the section for? When has he been growing in salary? But it's not part of the proposal.
Maybe, my lord, it was not part of the proposal.
In details, they can file an affidavit, my lord. Earlier occasions also, they had produced letters after letters, my lord.
You file it then. File
Yes,
an affidavit taking on.
And earlier documents also by way of an
Proposal has
affidavit.
been said that what communication has been received from
Yes, my lord.
Learned Study Council, secretary.
Elementary, my lord.
Elementary education. Will file an affidavit before the court, making on record the proposal that in favor of it. And the various range from the final. There the C. Borua for
reference number 7, my lord. Here our case is, we have returned it because they have sent it date of regulation is not sent. Thereafter, we have also writing later, we are now in process. I am appearing on behalf of account number 7.
My lord, regarding part of provisional pension, my lord, I am suffering.
provisional pension.
They have already stated that instruction has been to the treasury officer.
The department will also consider release of provisional pension and apprise the court and the status and by the provisional pension by the court. It's again on date of part, date of May.
8. Oblige.
Oblige.
8 of May.
8 of.
Yes. Usarani.
Usarani.
Yes, yes, education Usarani.
Paragraph 15, then 19 onwards, my lord.
Here. Now here, what is happening?
I have 4 pairs. One pair that has been granted, my lord. And pair number 2, lordship will consider, my lord. But pair number 3 and 4. Pair number 3, since I was initially appointed in the year 1994, and as per the order of regulation, my initial date has been counted for pensionary benefit. So, my lord, refixation of
So
senior.
are they irregular appointee?
Yes, my lord.
Where do you say that? What basis?
In fact, yes, he himself admitted in the petition, my lord.
Where?
Yes.
Paragraph 6, my lord.
Paragraph 6.
Yes, my lord.
Where?
The petitioner begs to state that on paragraph 6 of the petition, my lord.
Yes.
The petitioner begs to state that on 10th of August 2000, the Director of Elementary Secondary Education Department passed an order referring a cabinet decision conveyed a decision of the government of Assam to regularize 3511 numbers of so and so school teachers who were appointed irregularly during the period from 1/3/1991 to 30/11/1996 and onwards. That in terms of the circular published on 10th day of August 2000, the District Elementary Education Officer Kamrup Guwahati passed an order on 5th day of March 2001 by which regularized the service of the petitioner with effect from 1st of August 2000. So in terms of the cabinet decision, the service of the petitioner was regularized with effect from 1st of August 2000. Man. His appointment was.
And he has received from 2000 his salary.
He has received salary from 2000, 2001. No?
Yes.
Yes, Mr. Sharma.
My lord, though were categorized as irregular, not illegal, my lord, the appointment order at page 15. Initially, we are appointed against the government sanctioned post, but for different reason, we did not receive salary. And as per Annexure 2,
No, now you are claiming from which date? 95.
95, initial date, 95 to 2021.
You are irregularly appointed.
Yes, my lord, in 2000.
And you have been adjusted in some post.
Second post, yes.
So that is covered by the judgment.
Yes. But pair number 3, my lord, pair number 3.
Refixation of seniority.
Yes, my lord.
That also is not possible. How is it possible?
My lord, because my initial debt has been counted for the purpose of pensionary benefit, my lord.
Only pensionary, not seniority.
But when my turn come, my lord, then seniority, I will lose my seniority.
Where is that appointment order? Where is that your regularization or appointment order?
My lord, regulation page 23, initial appointment page 15.
Not initial, after the government has taken it. Where is that?
My lord, page 16, this is the notification issued by the authority.
24 is the order, my lord.
Then as per that notification.
24.
Yes, page 24.
First 21, then against readjusted.
23 is the type copy.
Yes, my lord. Page 21.
Yes.
Page 21, as per cabinet decision, my service has been regularized with effect from 1/8/2000. Then there was some dispute, page 22, with regard to,
In view of this division by judgment, you are not.
I have seen, my lord. Regarding seniority, there is no mention.
No, no, seniority will otherwise, see, if your claim for the earlier part is not available, how can you claim your seniority?
Since I'm claiming for pension from day one, so my seniority may.
That is only for the whatever services you have rendered. Let us say you are rendering services uh, prior to your regularization.
Yes.
There are judgments, there are orders that it can be counted for
From day one.
pensionary benefit. Can you say that it can be counted for seniority? It has to be from the date you regularize.
But if seniority is not counted from day one, my lord, I lost my seniority when the.
No, no, it is not counted because that period is not considered to be a regularized period.
My lord, I have not been paid salary during this period. So my seniority may be counted. My
No, no, cannot.
lord, with regard to pair manner P and 4, I will submit representation. They will consider, my lord.
No, no, no direction. You may submit representation on your own. We are not stopping you, but you can't direct.
Let it come after vacation. I will
No
inform.
vacation.
In fact, in the division bench judgment also, my lord, it is clearly mentioned, paragraph 21, my lord. In that case, the past service was counted for purpose of pension only.
You are getting your salary from what the earlier period, and you are getting your pension. What more?
Earlier period from 95 to 2022, I have not received.
You are getting it from 1/6/2003 to 31/3/2005. That you
Yeah.
have got it.
Yes. Thereafter 2005 till date, I have received.
Thereafter you have got it. So the
Prior-
earlier 95 to 2002, you did not get it.
As per division bench judge. But regarding seniority, that
Seniority also not good.
they will consider.
Seniority has to be on the day you are brought into the service. Catered.
They will consider, my lord. They will consider my regarding prayer number 3 and 4.
No. Will not be proper.
And then
Not be proper.
I'll obtain instruction from my client, my lord, regarding
Instructions. What instructions are there?
regarding the prayer 3 and 4.
We are closing it.
With it,
We are closing it.
with a liberty to approach the
But
authority.
While representations will not stop it. But saying that you have given us liberty means that they are under duty bound to consider your representation. But that is what that direction can in the face of this
Regarding refixation. Fixation means my seniority. From who is that my seniority will count?
why don't you understand?
Yes.
Seniority has from the date you are born into the service.
From 2000 or 2003.
No,
That-
you come into the service from the date this order has been passed.
My lord, there are two orders, my lord. There are two orders. Page 21 with effect from 1/8/2020. 2000. Page 21. This service has been regularized with effect from 1/8/2000. Then my service has been again regularized with effect from.
No, pursuant to the cabinet decision, which is the order.
This is my lord. In pursuance of the government letter 10/8/2000. First two line. My is hereby regularized with effect from 1/8/2000. Then again, my service has been readjusted again from 11.
Where is the cabinet decision? Is it available here?
Cabinet decision.
Circular is there, my lord.
Circular is there, page 18.
Where is the circular dated?
10/8/2000.
10/8/2000.
Yes.
10/8/2000.
Yes.
Yes, my lord.
And as per that notification, my service has been regularized from 1/8/2000.
It has to be from 2002 only.
Page 21, with effect from 1/8/2020, service has been regularized with effect from last sentence.
When is this letter issued?
5/3/2001.
Huh?
5/3/2001.
5/3/2001.
Yes. The affidavit also have not mentioned from which that my seniority will be counted.
Okay, 5/3/18/2000.
Yes.
You are regularized with effect from 1/8/2000.
Yes.
Okay. So
My seniority should be at least counted that from that day also, if not from my initial date of joining.
we heard when I talked to the court. Praying for director release the amount of arrear salary amounting 1,29,881 for the period 1/6/2003 to 31/3/2005. So a further prayer is made for release of arrear salary with effect from July 1995, 10th of December. So the petitioner has also prayed for the seniority, taking into account his initial date of joining, 1994 as a registered. So the writ petitioner claims to have been appointed as an assistant teacher in Pani Vidyapeeth Middle School, Patu, Pati, on purely temporary basis by ordination 13/1/1994 by the DPO. However, the petitioner is, was unable to connect his joining letter. After rendering his service as an assistant teacher, his salary was paid till June 1995. So, thereafter, despite his regular and continuous service, the authority did not release his salary till December 2000. The state of Assam had taken a cabinet decision to appoint teachers, school teachers, to regularize 3511 numbers of LP/senior basic/junior basic/ME/MEM/higher secondary school teachers appointed irregularly during the period 1/3/1991, 30/11/1996 and on. terms of the circular, subject or death of office of person be kept in the competent authority regularize services expenditure with effect on however, spite of these services being recognized is salary and salary by the president of you of communicating by the EU approved that budget and retention posts are not available as such, spite of the economic recognized salary does not is pertinent but that there is no view by but it does not dispute the fact that his case was considered by cabinet for regularization of five as a part of 511 numbers of who were irregularly appointed in the period of 191 and some of the some of the living benefits areas are these repetitions came to be allowed to be state required to be considered as determined one of the by judgment and order dated 24 by 2023 determined gave the allowed the pension benefit interfered with the judgment of the Honorable Judge and as well as the order past review and they were divergent that the pension benefit held that important that we not have been particularly the areas that as they were irregular the part 5 claim made by the that were covered by the in the meantime, however, first prayer made the him release of an amount of 609 and severe salary for the period 1 5 as considering the fact that the significant error and help opportunity that irregular teachers cannot be granted arrears and for the period prior to the remuneration. So must be prayer arrears and the effect of July 1995 then stand. Proper is prayer for the seniority. The department authority example and even of that has been regularized as the with effect of 1/8,000 for the ordination by one by one its seniority and counted the effect of 1/8,000. In terms of the above, that right. Order. Yes,
Well, in this case, well, 3 persons were well, initially appointed as master roll worker, well, both all of them were appointed prior to 1993, 1/4/1993, and well, subsequently service of all those 3 persons were regularized. All of them were well, identical name, Robin Borough, and well, all were in the same department and well, same division, PWD department under Nolbari division, madam. Subsequent and they were getting salary, madam. Present petitioner was getting salary till.
His name is also Robin Borough.
Yes, madam. All three are namely, madam, Robin Borough. So, madam, service of all of them were regularized with effect from, madam, the 22/7/2005 by an order dated, madam, 7/10/2005, and petitioner was getting salary till 2013 August. So thereafter, due to identity mistake, the petitioner name has been dropped. And thereafter petitioner filed an RTI application. Lordship will find that page 48. Then after getting this reply, he came to know that service of only 2 persons were regularized out of 3 Robin Borough. May I read, my lord?
Yes.
With reference to the subject cited above, I have the honor to state that during the time of submission of proposal for regularization of the master roll and workshop staff who were engaged prior to 1/4/1993, there were 3 identical names of master roll labor. That is Robin Borough, son of Tumbha Borough. Number 2, Robin Borough, son of Meadow Borough. This is the present petitioner, my lord. And Sri Robin Borough, son of Nobin Borough. All of them were engaged prior to 1/4/1993 and have been working under Nolbari, Samota and Dhamdhama rural subdivision respectively. That's a proposal of regularization of master roll services. A list of consisting 239 numbers of master roll labor were submitted to the office of the chief engineer PWD Rural Assam Chanmari Guwahati for onward transmission to the government for sanctioning the post. But out of these 2 master roll workers were rejected by the government as they were engaged after 1/4/1993, and subsequently 237 numbers of posts were approved by the government filed letter number so and so dated 30/9/2005 against this division, and accordingly the then executive engineer had passed an order by this office order number so and so dated 7/10/2005 for regularization of master roll service whose name are included in the government approved list, and the entire government approved list were forwarded to all assistant executive engineer under the division for information and necessary action accordingly. Thereafter,
The assistant executive engineer, Nalbari Rural Road Subdivision, took out the name of incumbent from the government approved list under his subdivision, including the name of Sri Robin Boro, son of Tumbha Boro, and prepared his monthly salary under regular cadre with effect from 22/7/2005. Similarly, the assistant executive engineer Samota Rural Road Division also took out the name of incumbent from the government approved list under his subdivision, including the name of Sri Robin Boro, son of Meadow Boro. This is the present petitioner, and prepared his monthly salary under regular cadre with effect from 22/7/2005. In the meantime, 22 numbers of master roll labor, including Sri Robin Boro, son of Nobin Boro, who was working under Dhamdhama Rural Road Subdivision, were transferred to the newly created Nalbari State Road Division before receipt of government approval list. The service of Sri Robin Boro, son of Nobin Boro, has been regularized against serial number 157 of government approved list out of 237 numbers of posts. Since then, his salary has been paid under regular cadre State Road Division with effect from 22/7/2005. In the meantime, Sri Robin Boro, son of Tumbha Boro, who was working under Nalbari Rural Road Subdivision, expired on 9/12/2011. Hence, at the time of submission of proposal for annual retention for 2012-2013, the division remarked against Robin Boro as expired, for which name of Robin Boro was deleted from the list of annual retention received from the government. On deletion of the name of Robin Boro from the annual retention list of 2012-13, no more Robin Boro was in existence in the list of annual retention. But another Robin Boro, working at Samota Rural Subdivision, continuing his salary as usual. The anomalies were later detected at the time of submission of proposal of annual retention for 2013-14 to government. On detection of these anomalies, whole matter was scrutinized and found that the practice of enjoying salary, etc. by one Robin Boro still continuing without any annual retention, as well as when the matter come to the undersigned, being the executive engineer, had started an inquiry to trace out the real fact, and after inquiry, the matter thoroughly, it is found that
What is the position now?
well, the report was called for.
In the meantime, he expired.
He expired.
He expired.
He
And
never regularized.
initially wrongly regularized, but subsequently when it came to the notice of the authority that actually his name was not approved by the authority, he started working as MR workers, and till 2013, from that period till his death, he continued as MR.
But in the subsequent paragraph, it is specified that my service was regularized. In fact, service of Robin Boro, son of Tumbha Boro, was not regularized.
Where?
But in the subsequent paragraph, I am coming, Malad. Though the three numbers of Robin Boro were engaged prior to 1/4/1993, the Robin Boro, son of Tumbha Boro, working under Nalbari Rural Road Subdivision, was not included in the list of proposal for regularization. But only two numbers, that is Sri Robin Boro, son of Meadow Boro, this is petitioner, Malad, and Sri Robin Boro, son of Nobin Boro, who has been working under Samota and Dhamdhama Rural Road Subdivision, were included in the list of proposal for regularization submitted earlier from this end. Accordingly, government has approved only two numbers of Robin Boro against serial number 63 and 157 in the government approved list. But service of Sri Robin Boro, son of Tumbha Boro, working under Rural Road Subdivision, was also regularized against serial number 63 of government approved, though through oversight by the executive engineer. Perhaps the mistake was done due to the identical name. On the scrutiny of annual retention, it is seen that this division received annual retention for the year 2006-07 in respect of 237 numbers of regular master roll labor, grade 4, which included 22 numbers of master roll labor in respect of Nalbari PWD Rural Road Division also. But the annual retention for the year 2007-08 up to 11-12, division has received at least 200. Well, I am coming to the relevant para now. In this regard, it may be stated that the concerned executive engineer as well as concerned staff also unaware in the matter and could not detect the mistake happened at the time on the ground that both Robin Borough was working in different subdivision. So existence of two Robin Borough against one sanctioned post was not come to the knowledge at the concerned authority. Even the Treasury Office could not detect the instant case till then. However, the mistake has been continued unknowingly from the time of regularization up to the submission of proposal for annual retention of 2013 and 14. And after proper verification, it is found that the service of Sri Robin Borough, son of Meadow Borough, has been working under Samota Rural Road Subdivision, whose service has been regularized against the serial number 63 of government approved list. This is the present petitioner, which is genuine. And annual retention was also received from the government against his name up to 2011-12. But his name has been deleted from the retention list wrongly when Sri Robin Borough expired on 9/12/2011, whose service was not regularized by the government against serial number 63 of the government approved list. So the matter is therefore placed at disposal of your honor for a suitable solution of the following issues at the same was not identical from the side of concerned officer and staff of the division. To arrange ex post facto approval for regularization of service of late Robin Borough posthumously, who was engaged prior to 1493, and instruction regarding preparation and submission of the family pension. To receive the annual retention with effect from 12/13 up to 13/14 in respect of Robin Borough, whose service has been regularized against serial number 63 of the government approved list and has been serving in Samota PWD. His service book was also prepared while he was in service. So, my lord, this document has been received by the petitioner through RTI. So, my lord, now they are, my lord, disputing this document that they have filed their affidavit, my lord. In affidavit, they have disputed this document.
Paragraph?
Paragraph, my lord, I am coming, you know. Lordship will find that paragraph 6, my lord. Paragraph 6 of their affidavit. Paragraph 6, paragraph 9, my lord. May I read, my lord?
Yes.
Paragraph 6, I am reading, my lord. As regards the statements made in paragraph 4 of the writ petition, the deponent humbly begs to state that the above mentioned so and so state that during the time of submission of proposal for regularization of the master roll laborer, there were three identical names of master roll laborer: Sri Robin Borough, son of Tumbha Borough. His date of joining was on 11/9/87. Sri Robin Borough, son of Matiram Borough, his joining date is 11/3/187. And Sri Robin Borough, son of late Nobin Borough, their date of joining was 19/5/90, and all of them were engaged under three different subdivisions within the jurisdiction of respondent number 3, that is Nolbari, Samota, and Thamthama Road subdivision. In this regard, it is stated that for regularization of service of master roll laborers, 237 number of so and so, and accordingly service of 237 numbers of master roll laborers are brought to the regular cadre in the pay scale of so and so, but in the said approved list, the master roll labor, the name of petitioner husband was not included for regularization of his service. In the said list, at serial number 63, another Robin Borough, whose father's name was Tumbha Borough, his date of joining is 1987, and serial number 157, again another Robin Borough, whose father's name is Nobin Borough, his date of joining was were included for regularization for service. So they are disputing that document. They are saying that Robin Borough, son of Tumbha Borough, was regularized. In fact, document is saying,
Who has filed this affidavit?
Affidavit has been filed by respondent number.
Chief engineer.
Yes, my lord, chief engineer.
Yes. So why don't you give post facto approval? Give post facto approval and complete the matter. The problem. Where is the problem here?
I have so many disputes, Lord. Lordship may come may come to page 19, Lord.
19.
Yes. Lordship, may kindly see the name of the person deceased, Lordship, late Robin Borough.
Hmm.
Lordship, may kindly see the other side, name of the father, late Matiram Borough.
Matira.
So petitioner is the wife of this Robin Borough, whose father's name was Motiram Borough. In respect of for this person, she is claiming pension. Lordship, may kindly see the service book, Lordship. Page 39. Second line, Lordship. Father's name, Meadowborough. Page 39. So this person whose service was regularized in whatever manner, his father's name was Meadowborough. And the person died, his father's name is Motiram Borough. Now, Lordship may come to the writ petition statement. Page 6, paragraph 5. Paragraph 5.
Paragraph 5.
Yes, Lord. Page 6. That in the service record, the name of the father of Robin Borough was recorded as Meadowborough. Meadowborough was in fact Robin Borough's father-in-law. The matter was brought to the knowledge of the concerned authority, and the authority was aware of Robin Borough's father name, but was recorded as Meadowborough instead of Motiborough. Now, this is the statement of the petitioner. Petitioners means wife of some Meadowborough. Lordship, 3 birth certificate has been submitted by the petitioner who was alive then. 3 certificates from 2 different schools. In all 3 certificates, his father's name is mentioned as Meadowborough. Yes. One is original, 2 photostat copy.
I have Annex 1 document at Annex 5. Let me see that document.
Yes. Then
So the person who was in service, according to him, his father's name was Meadowborough, but according to the petitioners, the person Meadowborough against whose name he is claiming pension, his father's name was Motiram Borough. That is one.
That is saying that Meadowborough and Motiram are one and the same.
No, not saying.
No, man,
Not saying.
Meadowborough is the father-in-law, my lord. Actually, Motiram Borough is his father.
Petitioner, that is the wife is saying Meadowborough is the name of her father. That is Robin Borough's father-in-law.
Where is
Paragraph 5.
Paragraph 3 also, lord.
Meadowborough? Fathering. Fathering. Whereas the birth certificate says otherwise.
Record says otherwise. That is one, Lord.
Why don't you bring it on record here?
Lordship called for records, Lordship records. When records came to me, Lordship, these facts are there.
Bring it by. You get an opportunity to prepare. So essentially what you're saying is that the statement made in para 5 is correct.
Also, that is the statement of the petitioner. But the person who was in service, he never disputed that his father name was Meadowborough. Because these birth certificates were submitted by him only.
Lordship, may kindly see Annex 5 of my writ petition.
Page number?
Page number 35. This document, there was an, my lord, inquiry, my lord, while he was in service, my lord. This document issued by executive engineer to the assistant executive engineer. May I read, my lord? In enclosing a photocopy of government letter number quoted above, you are hereby informed that the school certificate issued by headmaster of Paschim Suradi Boro Madhyam School and submitted by the person concerned, the name of father of Sri Robin Boro is Sri Meadow Boro, as well as in the master roll pay voucher of January 1989-90, the name of the father of Sri Robin Boro is Matiram Boro. Over and above the office order number so and so, it is seen that Sri Meadow Boro is a father-in-law of the Robin Boro. In view of the above inconsistency, the higher authority is seeking a clarification as regard actual name of father of Robin Boro.
You bring that in record. These are your certificates.
Yes.
You are saying Motiram Boro. What you say? Meadow Boro.
Meadow Boro.
Your father's name is Meadow Boro.
Okay, what the person himself is saying that my father's name is Meadow Boro, that is more important than what the officer is saying.
Lordship may kindly come to the next page, page 36, annexus 6.
Yeah.
This was the letter issued by the executive engineer to headmaster. The headmaster was requested to furnish with reference to the subject above. I have the honor to inform you that the school certificate issued by you and submitted by the person concerned, the name of father of Robin Boro is Sri Meadow Boro, as well as in the master roll pay voucher of January so and so, the name of father of so and so is Matiram Boro. Over and above the office order number so and so, it is seen that Meadow Boro is father-in-law of the Robin Boro. So you are requested to inform the actual name of father of the Robin Boro for onwards transmission of the higher authority. Now, my lord. Page 37, my lord. This is certified that Robin Boro, regular worker, son of Sri Matiram Boro, inhabited from so and so. His father address was village so and so.
Get this thing on record. You address this. Let him file the affidavit.
Mal.
Standing counsel PWD is permitted to bring on record the birth certificate available on record, which shows that the name of the father, which shows that the late husband of the pensioner is Robin Boro, son of Meadow.
No.
Then
the person whose service was wrongly regularized, his father's name was Meadow Boro. Whereas the petitioner is claiming pension in respect of a Robin Boro whose father's name is Motiram Boro.
Bring on record the birth certificate available on record with the department, so that the person was given the benefit. He was given benefit.
For some period of time.
So he is the person.
No, he was wrongly. No, Lordship, I can even store that only one document law. One document law, it will make clear law. Lordship may kindly see page 20. 20.
Yes.
Lordship may kindly see the date of his appointment, engagement as master or Lordship. Down below, 11/3/87. 11/3/87, his date of engagement. Then Lordship may come to the regularization order. Two pages I am referring, Lordship. One is page 26. Page 26. 63, serial number 63. Page 26.
Yes.
Serial number 63. Lordship may kindly see the first column, date of engagement, 1987. Lordship, he was engaged on 11/3/87, not on 1987. Another Robin Boro is there, Lordship.
There are 3 Robin.
No. 3 Robin Boros are there. Only 2 Robin Boros' name were approved by the government.
That's what they are saying.
No, in this Lordship, his name was not there.
No, that is what the claim of the Pensionary, that there were 3 persons who were regularized. One was left out.
Not left out. 3 persons, I mean, in this list, left out or not, that I am not aware. In the approved list, 2 Robin Boros are there. But as the subdivisions were different, due to some confusions, his service was also regularized. Whereas in the approved list, his name was not there.
Five.
Lord, may kindly mention this birth certificate. Otherwise,
Bring on record the birth certificate available. Respect of person. Was granted the benefit of
who has been granted the benefit of regularization for some period what?
as failing to the record.
4 weeks. Vacation certificate.
This recording.
Obliged,
Let him
sir.
bring it on record.
Lordship, we have received the instruction. As per our instruction, the letter is sent to the principal through speed post. And as per tracking consignment, the letter is delivered in the address of the principal on 9th of February.
Where is the technical council education? Education. This is elementary.
Lordship,
I think it's
secondary.
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 Principal is not before the court.
Yes, before the court, Lordship.
No,
As per
anyone-
my instruction, is not take, in spite of receipt, is not taking any step.
Anyone
Even
represented?
inspector of school.
Is he represented by anybody?
Nobody, no notice was yet to be issued.
Or no notice of the
Not yet to be issued, Lordship. Instructions, direction given to inspector of school, Lordship. Government advocate. He may communicate to the principal.
he heard done it. As per the instructions submitted before this court by the Accountant General's office, you can see that the Accountant General has forwarded. What do you call it?
Mugdi Milan Anchalik
Mugdi Milan Higher Secondary School,
Secondary School.
principal.
Has forwarded the necessary documents to the principal of the so-and-so school, who is this drawing and dispersal of the same was sent by speed post, and as per the tracking records, the same was seen to be delivered in the office of the principal of the so-and-so school. So, whereas the learned counsel for the petitioner, however, submits that he has not received a copy. He has not received the payment, as the principal has not released the GPF amount forwarded by the accountant general. So, in view of the submissions made by the counsel for the petitioner, for the respondent, the secondary education department will ensure that the GPF final payment authority issued by the accountant general is stated to have been sent by the concerned DDO, namely the principal, will be acted upon expeditious that the amount of the release of the court. That the matter be taken on 22nd of February, sorry, of
April.
by which date the instruction has status of the DF final payment or be placed before the court.
Lordship, fixing on 22nd of April.
22nd.
Lordship. All right.
That my learned friend has handed over a written argument, written submission, and I also intend to.
There is one aspect of the matter I thought either of the council or at least the petitioners have heard, argue, but that have not been heard. And in my mind, this is an area where we'll have to keep some observation with regard to the authenticity of that video record, whether it was true in terms of the Evidence Act, whether it is necessary to be true.
Yes, my lord, that I am clarifying, my lord.
The certificate under, I think, 66B, isn't it?
Yes, my lord. My lord would take my written argument, my lord. In fact, the exact point, my lord, with my.
Then let us keep it at the end of the board. We take it up to it, subject to convenience of the council.
Yes, my lord. Yes. I think for the six. Yes. In fact, there's a judgment, my lord, what from a lordship. The Honorable Delhi High Court has held that it has to be proved in terms of looking degree, but before that, if the document is an electronic record, the certificate under 65B is necessary also in case of a disciplinary proceeding. Exactly that has been stated while relying upon some Supreme Court judgment. I have included that in my written argument. And thereafter, it has to be proved accordance with.
We'll call it up after the end of the board.
My lord.
Because this is an area which will ultimately
I'll
decide.
satisfied because on last occasion I could not point out whether this was included in the rules itself.
Which
This
one?
this aspect, it is there in the rules, CDA rules. I have mentioned
It
it
is there in the
in these rules of 1995 pertaining to the services of this NRL employee.
what is there in the
Yes, my lord.
no, which aspect are you saying covered in the
My lord, this proving of documents at the time of inquiry proceeding, that is been taken care of.
okay, but then we examine
Yes.
at the end of the board.
The matter pertains to the non-payment of pension. And the last occasion, this court has directed to Education Department to file their affidavit. And department has filed their affidavit on 19/24.
Yes.
Yeah, but the affidavit is required from the respondent number 7, 8, and 9. Because they are the principal and the governing body of the college. They have not sending my pension proposal to the AG because their contention is that I have not submitted the non-liability certificate as per the audit report. But in my read petition, I have already submitted a for the governing body. It is on 20th July 2021 is. So now the governing body has given withheld my pension paper. So I'm a retired as a principal from a Dudna college, and I have submitted all my documents. I have submitted my audit report as per they have queried to me. All the documents I have been submitted, but nothing has been done by the authority. They have the query one after another. This if it is illegal, and they have to no affidavit has been filed. My reply is on.
Who represents the college? Anyone represents the college?
Name has been shown Mr. G. Pig, Mr. G. Payang and B. Pig.
Where are the council?
They have filed their workload number. Because they are the authority to non-submit my pension program. Because the audit report, the division filed by the respondent number 4, 11 to 4, they have said they have nothing to say because they are all are correct. The affidavit is filed by the audit director of audit local fund, Sri Fatis Kumar Saki. Is on para 4.
Our learned counsel for the constitution by the defendant seeking a prayer before the court for release of the pension payable to him for services rendered as a principal. Say, you retired as a principal
Yes, sir.
of the Dudnoi College.
Yes.
So, it is submitted by the learned counsel that there is no disciplinary proceeding pending, yet pension papers have not been furnished, forwarded to the competent authority by the college, present governing body and college authority. Although the governing body and the college are represented by the councils, none represents them when the matter is called up. Accordingly, since the college authorities are served notice and they are represented by the council, who, however, are not present before the day, this court is of the view that the college authorities should furnish the necessary status of the pension paper relating to the writ petition and as to why the same has not been furnished to the competent authority. So, we permit the standing council higher education. You are appearing for higher education.
Yes, Lordship.
To communicate copy of this order to the college authorities, namely
Number 6. Governing body.
Respondent number?
Respondent number 8, Principal Secretary.
6, 7, and 8. So, the respondents 6, 7, and 8 will thereafter place before the court as to why the pension paper of the writ petition has not been submitted in spite of the repeated request, in spite of the petitioner having superannuated and request being made by the copy of this order, the mark office of the study council, higher education or Robert that matter with staff.
It is not 6 to 8, it is 5, 6, 7, and 8. 5, 6, 7.
5, 6, 7,
8. Obliged.
We'll just come back in 1 minute. Yes.
Lordship, I am for the respondent number 4. I have not filed my affidavit. I may be allowed to file affidavit after some time because the problem is that I cannot support the case. I cannot oppose it also. I am one of the member employee. Though my name has been shown as MD, I am also drawing the fifth pay scale salary. And corporation is
So
not
what do you want to do? Do you want to file or not file?
I shall file after. Only thing I have already asked them whether they are in a position to give
Mr. Bhagavati Learned Council appearing for
respondent number 5.
respondent number 5 submits that you'd like to file a affidavit for which further time is not needs, for which he seeks further time. Prayer is not opposed by the Learned Council for the petitioner. Just after 4 weeks, enabling him to file the affidavit. And who appears? Mr. C.S. Hazarika for
1, 2, 6, and 7.
1, 2, 6, and 7.
RB Goswami for 3.
RB Goswami for 3. And Mr. Tolia for 4.
Your Lordship, that will be there. That may be fixed.
Date, I think 10th of May.
What?
10th of May.
May I take a call? My lord, this is a non-payment of my lord pension. So long, my lord, my learned friend from the government side submitting that, my lord, the pension papers are being processed, my lord. But now, my lord, I have received one communication from the petitioner, and I submitted the same before your lordship by way of additional affidavit. It is page 70, annexure A, my lord.
17.
70, my lord, 70, annexure A, my lord. Here, my lord, as per this communication, pension papers are already, my lord, returned back to the Deputy Inspector of Civil Nalwadi, my lord, whereby it was provided to submit fresh proposal and taking note of the, my lord, period for which the humble petitioner before your lordship eligibly, my lord, overstayed in service, my lord. "46 months, my lord. Period is rightly noted, my lord. But my case is that, my lord, this is because of the mistake committed by the departmental authority. He was compelled to overstay in service. And in this regard, my lord, I have from next page onwards, page 71 onwards, my lord, this issue was already decided by this honorable court, my lord. Under such circumstances, my lord, recovery may not be proper.
Your employed is what?
My lord, he is a teacher of the LP school. Lastly working as headmaster.
So let them examine it and pass an appropriate order, whether there was any contribution for his overstay. Otherwise, as per where that circular is there.
My lord, this judgment I have annexed, my lord.
No, there is a circular of the government. This judgment is.
And my lord, another important aspect of this matter is that, my lord, till date, my lord, the retirement notice was not served, my lord, and page 84, my lord, in this judgment, one Supreme Court judgment is already referred, where, my lord, departmental authority is duty bound to serve notice, my lord, page 84, paragraph 26 of the Supreme Court.
Why have you enclosed this judgment? For what purpose? Page 59.
59, my lord. Yes, it is also there, my lord.
For what?
My lord, only to ready reference, my lord.
For what proposition?
Here, my lord, if, my lord, authority, my lord, petitioner did not overstate by means of any fraud or representation, my lord.
Exactly. That same Rafiq Mashi.
Yes, my
lord. Law will be applicable.
Yes, my lord. And in this judgment, my lord, latest judgment, my lord, this Rafiq Mashi is also, my lord, referred.
Huh?
In the, my lord, latest judgment, I have referred, my lord, in the additional affidavit. Here, Rafiq Mashi is also referred, my lord. Page 86, my lord, of the additional affidavit.
Yes. Yes. What do you say?
But as regards the proposal for pension is concerned, my lord, Director of Elementary Education on 28th of March directed the Deputy Inspector of Schools to submit the fresh proposal to the Director of Pension, my lord.
Fresh proposal means fresh proposal after deduction of that overstay amount.
Yeah. As regards the actual date of superannuation, my lord, because he has overstayed for 46 months.
Oh. So what are you going to do? You are going to are you going to deduct the salary?
In fact, that information is not reflected in this instruction, my lord.
There is the circular of the state of
Yes, my lord. 2019 circular.
You have the circular.
One circular from the finance department.
You have it?
Today I don't have, my lord. Was it is?
Paragraph, my lord, 5, my lord, I have stated precisely the case, my lord.
Where is that notification that you pointed out, that communication? From the this page 70.
70, my lord. Now, my lord,
What does it
latest.
say?
It is provided that, my lord, as petitioner, my lord, overstayed. So, to resubmit the, my lord, pension proposal, taking note of his overstay, my lord. Contemplated, my lord, recovery. Hence, you are requested to take needful action in pursuance of the government in the personnel air department office memorandum number.
And what is the judgment? What is the judgment you are relying on?
My lord, the judgment, my lord, relying on, my lord, page 86, my lord.
Hmm.
Taking note of this traffic mercy, my lord. This honorable court, my lord, directed, my lord. Consequently, page 88, my lord. My lord, this is the direction. Consequently, this court therefore dispose of both the writ petition with the following observations and direction. The communication dated.
Well, what are the facts involved in the case?
Yes, my lord, this is page, my lord, paragraph 5, my lord, of the writ petition.
No, facts of the judgment that you're relying.
Yes, my lord, he also, my lord, overstayed, my lord. From the same
Show us,
district.
show us which paragraph.
Paragraph 2, my lord.
Hmm.
Both the writ petitions being connected are taken up for disposal by common judgment and order. The fact of the instant case is that the petitioner was initially appointed as stipendary teacher on so and so and a fixed salary position. The petitioner can underwent basic training and got the regular scale of response. There, upon the petitioner retired on 10/8/2021 as per the retirement notice issued by the Block Elementary Education Officer, Paschim Nalbari of the Nalbari district. After his retirement, his pension papers were duly sent to the Director of Pension. The Block Elementary Education Officer, Paschim Nalbari, issued a communication details transfer to the petitioner. However, it was mentioned that there was a excess dwell of monthly salary for the period from 1 to 2018 to 30/6 2021. That is an amount of rupees 17 lakh 7,100, and the petitioner was asked to pay the said amount through treasury challan and submit the challan copy within a short period for preparation of the pension, etc. He is entitled to, my lord, pension from the actual date of retirement. Paragraph, my lord, page 87, paragraph 18 of.
Any counter affidavit filed?
So long not filed, my lord.
No, my lord.
But there has to be an inquiry by the authority to find out whether you are at fault, whether there was any contribution by you for
My lord,
overstay in
in
service.
this regard, my lord, I have submitted one judgment of the Honorable Supreme Court also, my lord,
Hmm.
whereby it is provided that, my lord, if anything done, my lord, they have to file, my lord, a case, my lord, but there is no case is filed, my lord.
Anything done means?
No, my lord, nothing has been done, my lord, that the petitioner by misrepresentation, my lord, state in the service, my lord. Page 59, my lord, I have annexed this judgment also.
Yes, what do you say?
My lord may give me some time, my lord. As regards the overstay, whether is there any whether any as regards the entry of the date of birth in the service book, is there any manipulation or not, my lord, that I can by going to the service book I can ascertain it, my lord. So my lord may give me some time so that I can produce the service book, or I can put it down by way of an affidavit, my lord. Because in the judgment relied by my learned friend, in that case, my lord, service book was produced, my lord.
So that inquiry will have to be conducted. There has to be some inquiry by the authority to find out how you have overstayed.
Till date, my lord, they have not issued notice of retirement, my lord. It is only Barveli he was allowed to retire.
You get these instructions at an early date.
Yes, ma'am.
Produce this service book or file an affidavit to that effect.
Yes, ma'am.
My lord, my humble submission is that till date, my lord, no action may be taken, my lord, against the communication at page 70, my lord. Because petitioner instructed me, my lord, now they are whispering for, my lord, recovery, my lord.
No, recovery means is your pension already granted?
No, my lord. Only, my lord, the provisional pension of 12,000 is being paid, my lord.
So because if we grant a stay, don't you think your entire process for a release of pension will get suspended?
Only recovery, my lord, part, my lord, may not be taking place.
I don't think they will recover. They will adjust that amount and then give you the pension.
Adjustment is not permissible because, my lord,
That's right. So that is what it is not a case that they are trying to recover. You see, there are cases where you have already got a pension. Subsequently, they want to recover part of it. This is not a case falling in that category. You have not received your pension. Now, whatever pensionary benefits you are entitled to get, according to them, this overstay will be deducted.
my lord. So, my lord, that part, my lord, may not be.
Let it counting for the parties. The respondent education department will obtain the instructions as to what was the date of entry into service as well as the retirement date as per the service book of the writ petition, and also, if required, file an affidavit as to how the petitioner overstayed for a period of
46 months.
46 months.
Yes, ma'am.
For a period of 46 months, as is evident from the communication dated 13th September 2023, issued by the Director of Pension to the Deputy Inspector of School. So, let these instructions be placed before the court by the next week. Meanwhile, the respondents will not attempt to deduct any excess royal made by the petition during the pendency of the writ petition. Let the matter be listed again on 10th of May.
Obliged.
Deep level.
What is it?
And appears for the petitioner. The delegate from here appears to be the education department. Yes, anything?
Yes, the amount has been released to the petitioner, my lord.
But it's not here. It's submitted by the learned counsel for the education department. The amount claimed by the petitioner has already been released. However, in the absence of the court does not consider it appropriate. 52nd.
Obliged.
Hand us a copy.
Yes,
Check
ma'am.
with the owner. Writing of the email and director to payment date states that an amount of 6,05 has been sanctioned. Paper of the state communication also published that the amount is already sanctioned. Copy of the state communication retained the date report. That will be listed on 19th April.
Obliged.
May I please, Your Lordship? Lordship, matter pertains to suspension of Headmaster Lordship petitioner. Lordship was pleased to direct them to file affidavit, but till
Yes,
that
affidavit.
Lordship, SSA last time took time, standing
Yes,
counsel.
SSA. Yes, SSA. Where is your affidavit?
35 procedural.
Affidavit. You are given time to file affidavit.
Lordship, I have already received instruction, but in this matter, more than me, Lordship, it is the state government, Lordship, because they are claiming for reinstatement in service, Lordship, after the suspension order, which was issued on 18/8/2023, Lordship. So far as the enquiry part is concerned, Lordship, I have already, and that is already in my affidavit, I am prepared.
Lordship, here he was suspended and that suspension order has been reviewed, Your Lordship. It has been reviewed on 17/2/2024. He has been suspended. His suspension period has been reviewed, Your Lordship. And Your Lordship, he was given show cause notice on the 22/12/2023. And till date, he has not given any reply to that, Your Lordship. Again, a reminder was given. Till date, he has not given his reply. And because of that, Your Lordship, since department proceeding is pending, his suspension order has been reviewed, Your Lordship.
Who has issued the suspension order?
A suspension has been issued by the Director of Secondary Education, Your Lord.
And then the department proceeding?
It has been initiated by the Director, Your Lordship.
Then?
So cause notice has been issued, Your Lordship.
So whether the review has been conducted or not?
Lordship, the suspension order has been reviewed. This is the order, Your Lordship. A hearing was also conducted, Your Lordship. It was only after the hearing he was suspended, Your Lordship.
Where is the suspension order? Page number?
24.
Now, are there subsequently, have you drawn up departmental proceedings? Come to the suspension order 18/8.
Lordship.
There was some inquiry conducted pursuant to which you have placed him under suspension. But the suspension is pending drawal of departmental proceedings. Have you?
Lordship, after that on 22/12/2023, so cause notice was issued. Statement of allegations were also given to him, Your Lordship. Lordship, I can place the show cause notice, Your Lordship.
Yes, so your proceedings have started.
Lordship.
Lordship, Your Lordship, suspension order was issued on 18/8/2023, Lordship.
No, 17,
Suspension order, impugned order, Lordship, which I
18-8, yes.
18-8, and review order has been passed 17-24.
And department proceedings?
22/12/2023.
That is also banned 3 months, Lordship.
So
But
this
so far-
3 months is not such a cutoff,
Lordship.
arithmetically precise cutoff date.
Lordship.
The purpose is that whether you are unceremoniously or for elongated purposes placed on under suspension or not.
Lord.
You are placed under suspension. Maybe say instead of 3 months will expire when 1811
1811.
or maybe 1911.
Lordship.
And when was the departmental proceeding held?
20
Initiated?
22/12.
2212.
Lordship.
And
No reply was given, Your Lordship.
you have not filed any reply.
No
So
reply.
for my instruction, Lordship, reply already has been filed, Lordship.
All right.
Let them file affidavit, Lordship. I'll file my reply.
We have not received, Your Lordship. This
When was the show cause notice issued?
Lordship on 22/12 and on 16/2/2024, February of this month, this year, Your Lordship, a reminder was given. Till February, we have not received any reply, Your Lordship.
So ordinarily, yes, you are correct that within 3 months it should have been done. But not having been done, now the proceedings are there.
Yes, started.
We'll direct them to. They have already reviewed your suspension, which will expire in May.
Lordship.
So we can say that the departmental proceedings can be expedited
Within a stipulated time period.
within a stipulated time. Okay. Third, learned counsel for the parties. This petition is filed by the petitioner putting to challenge the suspension order dated 18/8/2023, whereby the petitioner, who was employed as the headmaster of Simli Tola High School under Gwalpara district, is placed under suspension as per provision of Rule 6(1) of the Assam Services Discipline and Appeal Rules 1964 with immediate effect. Stop. It is submitted by the learned counsel for the petitioner that notwithstanding the petitioner having been suspended with effect from 18/8/2023, the review of the suspension, for further continuation of the suspension did not take place prior to expiry of 3 months. So, although no affidavit has been filed by the respondent, learned standing counsel secondary education on instruction has submitted that the review of the suspension took place on 17/2/2024 and a copy of the said order has been placed before the court. By the said review, the period of suspension is extended until further order with effect from 19/11/2023. Stop. What is also submitted before the court is that on
22/12.
22/12,
22/12.
2023, department show cause notice was issued against the petitioner in the departmental proceedings against the writ petitioner. Stop. It is also submitted that the petitioner has in the meantime filed his reply to the show cause notice
On 28/2/2024.
28/2/2024. So the learned counsel for the petitioner submits that in view of the fact that the suspension order dated 18/8/2023 was not reviewed prior to expiry of 3 months, nor the departmental proceeding have been initiated before the expiry of 3 months. The writ petition is required to be allowed and the suspension order required to be set aside. So, para. In spite of opportunities granted, the respondents have not filed their affidavits. In the meantime, however, on instructions, the Learned Standing Council has submitted before the court and has also placed the order of review dated 17/2020. So, the law regarding review or suspension, the law regarding elongated suspension has been settled by the apex court judgment in Ajay Kumar Chowdhury. So, following this judgment, several judgments of this court in division benches as well as court in benches have been rendered. So, the apex court has laid down the law in the judgment and which is reproduced below, para 21, extract para 21. So, ordinarily, this court would have been inclined to interfere with the suspension order, considering the fact that the suspension has not been reviewed within a period of 3 months, prior to expiry of 3 months, nor the departmental proceedings have been initiated prior to expiry of 3 months. So, this court expresses displeasure due to the fact that in spite of notifications issued by the competent department laying down procedure for review or suspension prior to expiry of 3 months or initiation of department proceedings, such steps have not been followed by the department and repeated directions are required and suspension orders on that count alone are interfered. So, this court therefore directs the respondent department to ensure that suspension orders, all orders of suspension in respect of employment are required to be mandatory reviewed prior to expiry of 3 months in terms of the web data issued by the state government. Be that as it may, in the present proceeding, strictly speaking, the review of suspension did not take place prior to expiry. Nevertheless, the disciplinary proceedings have been initiated and the petitioner has participated in a fight with the fine. Under such circumstances, court, on the facts of the case, does not consider it necessary to invoke its discretionary powers to interfere and set aside the suspension and of the order of review at this stage. So, however, this court direct the respondent authority to expeditiously complete the disciplinary proceeding within a period of 60 days from the date of receipt of a certified complaint and filing necessary orders thereof. Even the charges made against the petitioner are found to be not sustainable during the disciplinary proceeding, that the petitioner shall be reinstated in service with immediate effect, and the period of service and the period of suspension will be treated as period or two. So, with the above observation, petition stands before the
Lordship, may I make a prayer? Lordship, at least 90 days may be given, Your
No, no.
Lordship.
What?
Lordship,
This file
because,
reply, you have to continue.
Lordship,
We are not interfering with it.
Lordship,
In the face of judgment of the court.
Lordship, Lordship. It's because of the election,
And-
Your Lordship.
No election. You stated that because of election you are unable to do it. Why this has not been given a ground?
Lordship,
And you are conducting yourself somehow that office memorandum has laid down very categorical. How this to be done?
Lordship,
Obliged.
obliged.
Office memorandum. Yes. Interim order. Yes.
As per last order, government was supposed to file affidavit on 5th of this April 2024, and thereafter to list this matter on 9th.
Yes.
Lordship will be filing the affidavit tomorrow, Lordship. Because some additional affidavit has been filed by the petitioner, Lordship. So we are also replying to that. And that's why it is taking little
This is
time,
about
Lordship.
criminal and disciplinary. Is there an interim order?
Interim order is passed last of it,
To the effect of?
not to take any court measure. And actually, we have prayed for suspension of the departmental proceeding because Lordship has just now developed the departmental proceeding. The final order has been issued by the inquiry officer, and thereafter I have been given the notice to give reply to the finding given by the inquiry officer. I have given immediately the reply, and the finding given by the inquiry officer has been set aside by the disciplinary authority. Now,
The inquiry officer order is in your favor.
no. Inquiry officer has said that the charges have been proved beyond reasonable doubt. I have not given any opportunity to examine any witnesses. I have filed application, and thereafter, Lordship, the authority, disciplinary authority, has set aside the inquiry officer's.
Some interim order is there.
Lordship, so interim order to continue.
Yeah,
And-
MS, granted. How much time do you want?
1 week will do, Lordship.
2 weeks time. File their affidavit. And interim order passed earlier will continue.
Lordship.
It's the matter like 2 weeks.
Lordship.
The Lordship kindly peruses the last order, the order dated 18/3/2024. The Lordship will see, my lord, notice of motion returnable in 4 weeks. Insofar the prayer on interim was concerned, my lord, it was returnable by 2 weeks. And today it was fixed for the consideration of interim order. Now there's a notification, my lord, which the Lordship will find at page number 18. Page number 18, my lord, a notification dated 21st June 2012. It says, in pursuance of the approval of cabinet held on 7/6/2012, the governor of Assam is pleased to order that henceforth all administrative department, heads of department and heads of offices of district shall issue provisional pension, provisional family pension and DCRG to all retired employees, government employees of the state government as admissible soon after their retirement till the final PPO is issued by the AG and the Director of Pension 1969. It is clarified that the retired government employee against whom any departmental or judicial proceeding is continued, no DCRG shall be paid to him until the conclusion of such proceeding and issue of the final orders thereon. So, if there is a, my lord, departmental or a judicial proceeding pending, DCRG should not be paid, but then the family pension will have to be paid. Otherwise, my lord, difficult
You
to
are
sustain.
here for family pension.
Provisional.
Provisional pension, my lord.
Huh.
So, that is my prayer. And if your lordship,
No, why is the pension not released?
No, that is something which my learned friend on the opposite side will have to clarify.
You are under suspension.
There was a DP pending,
Hmm.
and there was a departmental proceeding.
That DP was instituted while you were in service.
Because I was arrested, my lord, on 15/12/11.
Whatever the reason may be, it was instituted while you were in service.
Yes, ma'am. While I was in service.
Then before your superannuation, it was not completed.
Not completed. And what they did, my lord, if your lordship kindly turns to page number 49. Page number 49, there's an order dated 28/9/2023. And it says, my lord, second paragraph, Whereas a departmental proceeding was initiated against the incumbent under Assam Service Discipline and Appeal Rules 1964 by appointing an inquiry officer and a presenting officer to inquire into the charges and directed to submit a report, whereas the report in this regard was submitted by the inquiry authority dated so and so, whereby it was stated that the charges framed against Dibakar Mali could not be established due to lack of sufficient evidence. In view of the above, DP case number against Dibakar Mali bearing so and so is hereby disposed of, and a period of suspension with effect from so and so is treated as on duty for all purposes like increment, leave, DCRG, pension, etc. So they have disposed of the departmental proceeding, and the criminal proceeding is pending. Now, pendency of a criminal proceeding cannot be a ground to withhold my pension. Law has been laid down, my lord. Honorable Apex Court, if your lordship kindly turns, page number 50. Page number 50, my lord. Paragraph 2.
Yes.
Page number 50. Crisp and short question which arises for consideration in these cases is to whether in the absence of any provision in the pension rules, the state government can withhold a part of the pension or gratuity during the pendency of the departmental criminal proceedings. And the answer question is at paragraph 2. And the answer is, my lord, at page number 56. Page number 56, paragraph 14. It says, Article 300A of the Constitution has been, my lord, quoted. And then they say, paragraph 14, once we proceed and the premise, the answer to the question posed by us in the beginning of this judgment becomes too obvious. A person cannot be deprived of his pension without the authority of law, which is the constitutional mandate enshrined in Article 300A of the Constitution. So, pendency of a departmental or criminal proceeding cannot be a ground to
What does
withhold
the
pension.
pension rule say?
Pension rules, if your lordship sees section rule 22, it provides for, my lord, provisional pension. So they cannot, my lord, until and unless there is a judicial finding against me, they cannot.
What is the stage of the criminal proceeding?
That is going on, my lord.
No. Cognizance taken, not taken.
My instruction is charge sheet has not been filed till now.
Yes.
So all I'm praying at this motion, I mean at this stage, my lord, they will ultimately have to file their affidavit indicating their stand. All I'm saying, my lord, let the provisional pension be released so that I can sustain my family, my lord.
Yes. What do you say?
But probably my friend's submissions are not telling with his own statement, own documents, Lord. Lordship, may please come to page 49, Lord.
49.
Page 49, Lordship. Let me kindly see the first paragraph. Order dated 28/9/2023. Whereas Sri Dibakar Mali, Assistant Engineer under suspension, Guwahati Municipal Corporation was placed under suspension by order dated 26/10/2021 due to allegations of found accepting bribe money from the partner of the co-complainant, and he has been arrested on 22/10/2021. Lordship will kindly note the date. 22/10/2021. In respect of this case, Lordship, last paragraph is relevant. In view of above, DP case drawn against Dibakar Mali, Assistant Engineer case number hereby disposed of. Lordship, may come to page 44.
Yes.
Lordship, this is an application by the petitioner himself, Lordship. Lordship will see the first paragraph. With reference to the subject cited above, we have the honor to state that we were placed under suspension following arrest made by CM's Vigilance on 14/11/2022 in connection with SBCP case number 4 of 2022. Lordship, may kindly see the difference of dates, Lordship. In the first case, he was arrested on 22/10/2021. In the second case, he was arrested on 14/11/2022. So first case has already been disposed of, Lordship. This second case, another DP is pending. That is one. Secondly, Lordship, the document at page 39, page 18, Lordship. This is a direction issued by the Pension and Public Grievances Department to all the state government departments, Lordship. So in
which page?
Page 18, Lordship.
18.
Yes, Lord.
Here.
Lordship, this is in cases, Lordship, where the Assam pension rules 1969 apply. But so far as GMC is concerned, Lordship, they have a separate pension rule, Lordship. These rules of 1969 not applicable in case of GMC employee. So today morning, my instruction, though written instruction is awaited, Lordship. Today morning, they informed me that so far as the payment of provisional pension is concerned, Lordship, their consideration is on, Lordship, and soon they are going to take a decision in this regard.
That will be recorded.
Only that provisional pension, Lordship.
This
in the
commission
meantime,
will be recorded.
In the meantime, Lordship, I will file written. Immediately, I get the
Affidavit he
written.
will file and
I'll file an
matter will be finally adjudicated upon, but the
Lordship.
submission may be recorded.
Yes.
Heard that account. Meeting director responded with the pension. It has not been reduced. Was employed as an executive engineer, party regulation on 3006. Learned counsel for the petitioner submits that as per communication dated as per order dated 28/9/2023 by the Commissioner GMC, it was informed that in disciplinary proceeding, the charges in the disciplinary proceeding against the petitioner could not be established due to lack of sufficient evidence, and therefore the disciplinary proceeding is disposed of, and the period of suspension with effect from 26/10/2021, 23/3/2020. Learned counsel for the petitioner view of this order, there should be no bar. The respondent, the provisional bench, to release the pension, the regular pension of the petitioner. But at least for the present, provisional pension. He further submits that the criminal proceedings that are taken to be pending are still in the stage of investigation. No charges has been filed.
That is, I don't have the updated instruction,
To the best of your information.
To the best of my
Mr. Nayak, however, that there are two cases which are initiated, which are pending against the district. And in respect of one case lodged by the CM, there were two cases lodged by the CM cell. And in respect of one such case, the department proceedings have been concluded, whereas in respect of the other, the matter is still alive and pending, and it's still going on.
Second DP is on.
Going on. So, learned counsel for the petitioner convinced that the provisions of the Assam Services Section 69 are not applicable. Employees of the GMC, as there is a separate patch code applicable to the employees of the GMC. Be that as it may, since there is a departmental proceeding as well as criminal proceeding pending against the regular pension. However, the matter is under active consideration for release of provisional pension for the claim made by the is submitted that the department may consider release of provisional pension for the claim made by the within a short time. Yes.
It will be decided immediately.
It will take a decision within a short time. Take a decision in a short time that the claim release of Mr. C. Sharma for
That's for number 4, AG.
AG. AG is involved here also.
Unnecessarily, unnecessarily you can make the party. Nothing to do probably.
Does it require AG present here?
Not
But
required.
generally, AG we make party in pension matters, but
That's
if
in
he doesn't,
respect of state, you are not a state employee.
if he doesn't want, my lord, it can be striked off. There's no.
AG's
For
role
you to
comes,
decide whether you want or not.
AG is involved only in case of master roles and teachers role.
Because in
Other
some cases, AG also plays a vital role.
Teacher থাকে। So,
Sir B. Sharma, I feel
we take it.
the matter will be set up in 3 weeks.
Lordship, somewhere your lordship use the word verbal instruction. Verbal instruction.
As per verbal instruction. As per instruction. That's good enough.
No, I have not yet received written. That is what whatever over telephone.
Verbal instructions are also instructions. Unless we say written instruction. Instructions can mean verbal or
Written.
oral or written.
Lordship.
Oh, considering it's a pension matter, can I pray for a fixed date?
Tell me your date.
Yeah, any day. Lordship can have it on my lord 29th April, my lord.
For 29th, too early.
Then my lord, May, my lord, 7th May.
7th is holiday. Election
Eleven, I'm
day.
not coming.
Any fixed date, my lord. Subject to your lordship's convenience.
It will be on 17th. 10th May.
10th May.
10th.
Obliged. Deeply.
Obliged.
In this matter, my lord, transfer matter, my lord, we received the instruction that was brought on record by an affidavit. And in fact, my lord, petitioner earlier filed, my lord,
Petitioner is not here.
my lord, he will not come because, my lord, he
There is
case
an
is
interim order.
he will become infructuous now.
Ah,
Lordship, kindly see his transfer order, my lord, page my lord,
no, he is not here, so we'll pass it over for the day. Let it come.
no, my lord,
next week.
question is, my lord, we have the urgency is there, my lord, the election is there. Petitioner stay, my lord, status quo order was passed. Transfer order in 2022.
Then
Lordship,
we'll
kindly,
have it on immediately after reopening.
no, my lord, we have some problem, my lord. Because the election is
Then you
there.
call the council, inform the council.
No, he will not come because by better become infraction. Lordship, kindly see the court order, my lord, page, page 40. So we are, Lordship, kindly appreciate that we are facing problem, my lord.
Page 40.
Page 40.
Yeah.
Earlier order. Same order was challenged, my lord. Order that, my lord, petition number 2602/2002, order 19/4/2022.
I know, naam to-
Yes.
Who is the counsel for the petition?
A.R. Talukdar
A.R.
from
Talukdar. Please the name.
my lord, Lordship, kindly see page 41, paragraph 5. At this stage, the limited grievance raised in
Let
the
him come, let him come. We are displaying the name. Let him
yeah,
come.
because, my lord, status quo is required to be better.
Let him come. Yes. Yes.
May I please, your lordship, this is a case of fake currency of 500 rupees denominations.
My lord, here, charge sheet submitted, my lord.
The only prayer is, your lordship, the interim protection was given to me. For some more time, I may be protected, and within meanwhile, I'll go and appear before the trial court to take the bail.
Okay, heard. Learned counsel for the parties. It's submitted by the learned APP that charge sheet has been
My lord.
submitted by the
High charge sheet number 1078 of 23,
1078 of 2023 dated
3112,
31/12.
23.
So, accordingly, this AV petition stands closed. The petitioner is permitted to appear before the competent court before which the charge sheet has been filed. So, since there is an interim protection granted earlier by
Your good self.
order dated
Even increasing.
22/8/2023,
Yes, yes.
the same shall continue for a further period of 10 days.
Yes, yes.
By which time the petitioner will appear before the competent court and apply for regular
My
bail.
lord.
While considering the case of the petitioner for bail, the competent court will take into consideration
As per law.
the judgments rendered by the apex court in Siddharth and
My
and so
my lord.
and others disposed. I do.
My lord, here in the last occasion, Lordship was pleased to call from a report from the officer in charge, my lord, Dibrugarh, my lord. Today I have talked to my lord, officer in charge, my lord. He have prepared a detailed, my lord, report and sent it to the, my lord, SP office, my lord. On 3rd, my lord, 3rd April, my lord. And from SP office, it will come to our office, my lord.
So call it,
My lord.
Let the report come.
Yes, my lord.
It is submitted by the learned APP that the report called for is not yet received. And the same has been forwarded by the concerned IO.
OC, my lord. Officer in charge.
By the OC of
Dibrugarh, my lord.
Dibrugarh PS, not PS.
Dibrugarh.
Dibrugarh Hodor.
My lord. Dibrugarh. OC Dibrugarh PS.
Gaboro Potar.
No, that is outpost, my lord.
Dibrugarh PS to the jurisdictional superintendent of
My lord.
police, and the same will be forwarded to the office of the learned PP by the office of the jurisdictional SP. Learned APP, therefore, prays for some time. Mr. A. Hawari, learned counsel for the petitioner. After the matter be listed accordingly on. Take up time. Yeah, updated. Tenth of May.
My lord.
May it please your lordship. Your lordship, as per the office note dated 7th February 2024, we may be service upon respondent number 2 has not been completed yet. And so we may be directed to take fresh upon respondent number 2.
Lord, I am appearing for respondent number 3, my lord.
3.
My lord.
Who is respondent 2?
Officer in charge.
Huh?
Officer in charge.
Officer in charge. Furnish it through the office of the PP.
But here, my lord, one problem is that, my lord, by name is his name was mentioned, my lord.
Huh?
By name, his name was mentioned. No, no. Oh,
the OC.
Oh, OC, no, not name, my lord. We can represent, my lord.
This is for what? Cancellation. What is I for what? What is this I for?
It's regarding the harassment meted out to the petitioners in view of the in spite of the order passed by the honorable court regarding bail. So prayer before this honorable court for not to harass the petitioners in view of the pendency of the.
Who are the petitioners? Informant.
No. Informant is not a petitioner because accused persons who has been granted bail by this honorable court. Thereafter, in the pendency of that FIR, the officers are meeting harassment to the petitioners that to come up to the police stations and to
The petitioner is the person on bail.
On bail.
So what harassment has been granted, given to him?
He has been repeatedly been called before the to appear before the honorable before the court for police station to recording his views taken on numerous occasions. Despite this honorable court on a clarification that nothing has been happened to the FIR, impede FIR, and he has been granted bail.
Where is the bail order?
Lordships, page is annexer and annexer B, page 18. The bail has been granted on 6/5/2022. Whereupon this honorable court finds that page 19.
So he has been given on he was arrested and granted regular bail. Then
Till then no charge sheet has been filed, but without filing charge sheet any final report. The respondent concern has been repeatedly been called for him to appear before the police station.
And who is the respondent 3?
My lord, Sharat Chandra Das,
He's the IO of the.
then sub-inspector of that police station, my
You
lord.
are the IO.
My lord.
Why is he making allegations that you are repeatedly calling him?
My lord, he is not appearing before the police station for not for a single occasion, and kindly, my lord, peruse page number 46, my
Then
lord.
why have you
In
not
ex-
prayed for cancellation of the bail?
My lord, I have to be instructed, my lord. I cannot say right now, my lord, why not preparing for cancellation of bail, my lord.
When was the last time you appeared?
Already I have appeared because subsequently he has been beaten up by goons persons and he has also filed FIR before the same police station and he has already given a statement. But without taking those recourses, earlier.
No, what kind of an IA have you filed? What kind of prayers are you asking for? Appropriate action against for malafide intention of arrest is that you are already on bail.
Already on bail, my lord.
Without cancellation, how can they arrest you?
But the thing is that the actions on the part of the respondent authority, it is disgrateful on the part
Whatever it may be, disgrateful, you file complaint against their officers. What kind of an IA is this?
Lordship.
What kind of an IA is this?
I may be withdraw, Lordship.
You wasting
Lordship.
the court.
Lordship.
Heard learned counsel for the petitioner, the learned counsel take view of the court to withdraw the IA file. Accordingly, the IA accordingly stands dismissed. As not pressed. Not pressed. Dismissed, not withdrawn. Mr.
R. Sharma, my lord.
R. Sharma appears for respondent 3. Mr. D. Sharma for
Yes, number 1 and 2.
APP.
1 and 2.
IA accordingly dismissed.
Obliged. Obliged.
May I please, your lordship, here in this, my lord, I am, my lord, I am already transferred and joined in the school, my lord. I am a physically disabled person, my lord. And during pendency of this petition, my lord, the order was passed to directed me to join in the school. The order is a page 14, my lord, in my IA.
Yes.
With reference to the subject cited above, you are directed to submit joining report of Nurujaman Kaji, that is the petitioner, my lord, at Chaladanga ME school today, and above mentioned order, his duty at Shamacharan Kuti LP school will not be counted as duty as no stay order against this office order number quoted under reference at serial number 1 passed by Honorable Court order as well as the higher authority. Hence, there is a no interim order from this Honorable Court, and your lordship may pass the order is at page 11, my lord. Page 13. Last slide, my lord, your lordship may found it. The impugn order shall be made subject to the outcome of the repetition. So I have to directed, I am a physically disabled person, my lord, and I am directed to join in my transport school, my lord, at Chaladanga, which is at around distance 5 to 6 kilometers from my home, my lord. And I have a physical
Now, what do you want?
My lord, in this my lord, I am praying for my lord. I may be allowed to work from the Shamacharan Kuti till during this pendency of this petition, my lord.
No, no.
Let them
You are transferred from which school?
Shamacharan Kuti to Chalatanga, my lord.
So you have been transferred. There is no interim order. There is no stay.
No interim order, my lord, during pendency, my
By
lord.
filing this IA, it will amount to giving you a stay, which has not been granted by the court earlier.
No, my lord, my only contention is that, my lord, I may be only allowed from this school, work from this school, my lord. Your lordship may, matter may be.
Where is the transfer order? Let us see the transfer order. Is it there? Is it enclosed somewhere?
Page 37, my lord.
37.
In the repetition, my lord.
No, in the IA, it is not here.
Not, my lord, I have
It is not there in the IA.
No, my lord. In the repetition, my lord.
37.
What is it?
37. No, 37 is some, where is the original order? 36.
Page 24, my lord, Annex 5. Page 24, Annex 5, my lord.
For better academic environment, Shamachuran Kutti, MB School, Sri Nurjaman Khaji, assistant teacher Shamachuran
Allowed to work at Saral Donga.
Musural Langa, my lord.
Now, which order have you challenged?
I have challenged this order, my lord. Subsequently, your lordship allowed me to submit a representation, which was also disposed of, my lord, which I have already shown your lordship at page 37, my lord.
Right.
Now, my lord, both the orders I have been challenged. My lord.
So your current place of posting was prior to the order of transfer was
Shamachuran Kutti, my lord.
Samal Charan Kutti. And you have been transferred to
Chalat Danga, my lord.
Saral Donga. Now by this what do you want?
My lord, I just pray before your lordship, I may be allowed to work from this school only, my lord.
This means?
Shamachuran Kutti, my lord.
No, that is not permitted. Sorry. That is, we have already made it clear subject to outcome of the writ petition. Heard learned counsel for the parties.
In
This
that
I
case,
has been filed with the petitioner.
in that case, I may be allowed to withdraw this. Not press, my lord.
Learned counsel for the petitioner submits he does not wish to press the IA this day. IA accordingly stands dismissed, not pressed. Mr. P. Pegu, P. Pegu. G. Pegu appears in Education Department. Yes.
Obliged, my lord.
I plead it.
Yes.
My lord, today, my lord, I have filed an additional affidavit, my lord, appraising the honorable court regarding the recent development, my lord. My lord,
What is the recent development?
My lord, in the writ petition, my lord, I have challenged the transfer order. A transfer order, page 23, annexer 6. What happened, my lord? My lord, presently I am working in Borketi Education Club as accountant. And private respondent is working, my lord, in another block, Pope Nolbury. We are both, my lord, working in our respective post, my lord, for 8 months, 10 days. Private respondent also and myself also, my lord. And while, my lord, I am serving, my lord, in my block, my lord, or Khetri block, my lord, we filed a joint petition along with one, my lord, Rafiqul Islam, for mutual transfer. Rafiqul Islam is working, my lord, in Borgok, Bonbhag Education Block. And I am presently working at Borketi. We filed a mutual joint petition for mutual transfer. My lord, while my lord processing was going on, my lord, you lordship, a report, details report was submitted by the, my lord, by the district mission coordinator, Nolbury, page, my lord, 21, my lord. Page 21, my lord. A details report, my lord.
Yes.
My lord, page 21, my lord. May I read, my lord?
Yes.
Sir, madam, with reference to the subject cited above, I would like to inform you that the following lines and details report regarding the mutual transfer of Govinda Verma, myself, my lord, and Rafiqul Islam, block accountant under SSA Nalbari. Mission Director, Samagra Sangram Assam instructed to transfer block accountant and LDA accountant who have been working in the present block for 3 years with approval of the DC within the district, but not to be adjacent block. For 4 LD accountant and 21 block accountant under SSA Nalbari were transferred by the then Deputy Commissioner Nalbari by order number so and so dated 22/6/2023, copy and close. The information regarding along with service of different block Govindapur, my lord, my service record, my lord. Presently, my lord, I have been brought from Bonbhag and now serving at Borkhetri, my lord, for 8 months, 10 days. Remark, my lord, presently he is working in Borkhetri block and applied for mutual transfer to Borgok, Bonbhag.
Where is that application for mutual transfer?
My lord, page, my lord, 20, my lord.
22-0.
20, my lord.
Yes.
Page 20. May I read, my lord?
Yes, read.
With reference to the subject cited above, I, Govinda Pal, currently serving as block accountant in Borkhetri Education Block, hereby submit my request for mutual transfer to the Borgok Bonbhag.
Now, pursuant to this, what happened?
Pursuant to this, my lord, this report called for. This report indicates, my lord, since we are working for about 8 months, 10 days, transfer cannot be done. As because, my lord, there is some violation of circular. Now, my lord, in the meantime, impugn order has been issued. Page 23, my lord. 23. The following block accountant under SSA Nolbari hereby transferred and posted in my block, in the block mentioned against their name with immediate effect on their own interest. Where is my interest, my lord? My interest goes to my lord Bonbhag. Now private respondent has come. This impugn order has been issued in violation of office memorandum as usual, as well as 2 office memoranda, and on the other hand, my lord, against my interest. That's why, my lord, this honorable court status quo order was passed in earlier occasion, my lord. My lord, while my lord status quo order passed, my lord, now, my lord, by this impugn transfer order, I am, my lord, prevented to sign in my attendance register, and my lord, I am pressurized to go, my lord, Cook Nolbari.
A notice issued to the private respondent?
Yes, my lord, I have taken step, my lord.
He is not appeared.
Not appeared.
Yes. What is the?
Lordship, I have received the instruction, but Lordship, there is some more clarity is required. As per the telephonic conversation and instruction that I received, Lordship, this private respondent also applied for transfer, and after getting the report from the district mission coordinator, Lordship, the ADC taking into account every aspects of administration, Lordship, he has issued the order. But
No, but how can it be at his own interest?
Lordship, all those things I have seen, I had, so I have requested for more clarity. Lordship, may take it up after on the reopening, Lordship.
My lord, I may be allowed to put my signature in that. I'm daily.
That information, Lordship, I have just
my lord,
come to know that I have to get it clarified. Lordship.
No, there is a status quo order.
Yes, Lordship, but how they have prevented him, Lordship,
that should not be done.
My lord, only my lord, my
learned standing council SSA will seek time to obtain instructions in the matter. Mr. Manaf, learned council for the submit that notwithstanding the status quo order drafted on 27/3/2024 as a consequence thereof, the petitioner is still working as block accountant in
Borkhetri
education block. He has not been allowed to
put signature on that
signature in the daily attendance. Mr. Chaudhary, learned standing council SSA, something you'd like to clarify, like to complete instruction. The next thing. On 10th of May,
my lord,
a status quo order passed earlier because
my lord, only my little submission, my lord. My coercive measure could not be taken in respect of my lord, service, my lord. Their
coercive measures, your status quo is there already. What coercive measures do you put?
My lord, they are preferring to go, my lord. My lord,
if you want to go, you go. You have a status quo order in terms of the court. That's all.
With regard to the prevention, Lordship, I will inform them, Lordship, that if it has been done, it's wrong.
In the face of status quo order, don't intimidate.
That is not going to the, maybe the other reasons may be there, Lordship, but the officials, I don't think they will do it.
In fact, In
Will
fact,
not-
my lord, the impugned my lord transfer or absolutely nullified in violation of two circular as well as honorable.
We will examine that.
My lord, exactly,
And
my lord.
have you served copies of the affidavit?
Yes, my lord, I have.
Yeah.
served.
Copy of an affidavit has been filed by the petitioner today,
Yesterday, my lord.
yesterday. And the same has been.
That is on record, my lord. That is on record.
The same has been brought to report after.
Apply.
Yes.
Well, that furnished a written argument, madam. A written argument. Madam, has it, madam?
Yes.
My lord, I'll just explain the written argument. Madam. First, the list of dates, my lord. That would give your lordships the precise chronology of events, my lord. Thereafter, my lords would find the submissions with regard to the charges, my lords. 5 numbers of charges and why I have claimed that the charges are perverse. It's included there, my lord. What is the charge, the findings, and the submissions. Thereafter, my lords, the second ground, submissions with regard to further inquiries also there, my lords. Now, my lords, coming to the point, my lords, during the last inquiry, last proceedings, my lord had inquired as to is there a legal procedure to produce electronic records, my lord. Now, insofar as electronic records are concerned, my lord, as per the Evidence Act, in fact, Section 3, the meaning of evidence, it has been said, my lord, that electronic record is also a document and it will be called as documentary evidence. Now, thereafter, my lords, if a document is an electronic record, what is the procedure laid down to produce it in a disciplinary proceeding? Insofar as civil and criminal proceedings are concerned, Evidence Act would squarely apply and a certificate under 65B is necessary. Now, insofar as disciplinary...
You've not been able to find out any judgment.
Yes, I found out a judgment, madam.
Delhi High
Delhi High Court, but they have referred to Supreme Court judgments, madam, and they have come to the finding. I'll just hand over the judgment. Before that, madam,
What is the Supreme Court that referred?
Supreme Court, madam, both these matters, the judgments referred, the Supreme Court judgment which was referred, that was not with regard to a disciplinary proceeding, but an election petition. But the principles laid down there has been exported, madam, taken in that judgment by the Delhi High Court, which
So the principle is how to produce, how to bring a document on record.
Yes.
Electronic document on record.
Yes, exactly, my lord. That my lord would find. Well, the name of the judgment is Naresh Kumar Gandhi versus Cambridge Foundation, my lord. Lordship would come to paragraph 49 and 51, my lord. Very relevant, my lord. Paragraph 49, my lord. May I read, my lord?
49.
49. Page 44. Long judgment they have discussed. May I read, my lord? Recognition of the principle that if evidence against a delinquent employee.
Subsequent to Arjun Pandit Rao, there is another judgment.
Yes. The first was that judgment. They have just clarified, my lord. Supreme Court judgment has been clarified by Arjun. The earlier judgment was?
No.
PV Anwar, my lord.
PV Anwar has been
upheld and held to be the right law, my lord.
Right.
Correct law.
But subsequent to that, there is another judgment.
It's a clarification. It's called, my lord, Arjun Pandit Rao.
No. After
After that also, my lord. That I'll find out. I'm so sorry. I think
22, I think. Anyway.
My lord, I'll read paragraph 49. Recognition of the principle that if evidence against a delinquent employee is based on electronic evidence, the burden of proof lies on the employer is also found in the judgment of Madras High Court in such and such case decided on 23/11/17, where the court held that a staff cannot be thrown out of the institution solely based upon the CD which is admittedly and indisputably edited and dubbed or otherwise based on edited electronic evidence. It was observed that disciplinary proceedings initiated based on unauthenticated and edited version of the CD will affect the very root of the disciplinary proceedings. To the same effect is the judgment of the Patna High Court in Bharat Prasad Yadav versus State of Bihar, where the court held that the departmental proceedings will be governed by the principles laid down by Supreme Court in Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal, where the Supreme Court highlighted that a certificate required under Section 65B4 of the Evidence Act is a condition precedent to the admissibility of evidence by way of electronic record. The Supreme Court in Arjun Pandit Rao Khotkar in turn placed reliance on the judgment of the Supreme Court in Anwar PV versus PK Bashir, reported in such and further held that oral evidence in place of a certificate cannot possibly suffice as Section 65B4 of the Evidence Act is a mandatory requirement law. My lord would skip paragraph 50 and come to paragraph 51, my lord. So this it clinches the issue, my lord. This court is conscious of the observations of the Supreme Court that strict rules of evidence will not apply to departmental proceedings. However, as noted above, where the evidence sought to be pitched against the charged officer is electronic evidence and is alleged to be doctored, tempered, or unauthenticated, principles of natural justice require that the same must be supported by a certificate tendered in accordance with the principles of Section 65B. Any other conclusion, in my view, would lead to a finding of guilt and a penalty against the charged officer predicated on an electronic evidence which in a given case could be edited or tampered with to suit the employer, and the genuine device may contain evidence pointing out to the innocence of the charged employee. Conscious of this position of law, the school had taken the trouble of producing the certificate in support of the CDs, DVDs, after giving consent before this court in the earlier round of litigation. In this backdrop, it was essential for the inquiry officer to have insisted on a certificate being tendered in accordance with Section 65B of the Evidence Act, or at least a certificate which would have identified the electronic record in the manner in which it was produced, following the underlying principles of Section 65B2 and 4 of the Evidence Act. Now, my lords, in the instant case, it is an admitted fact, my lords, that there was no certificate. Now, insofar as my understanding,
Don't make any allegation that it was false, concocted.
no, it's there. That is also there.
Say that.
The burden lies on the respondent if they produce. That has what been held. Now, my lords, what I have.
Burden will come.
Yes.
See, when you make that allegation.
And the allegation is there. I'll come to that allegation directly, my lord. The second
You
inquiry.
don't say these allegations.
Yes, it's there.
False,
It's there.
doctor.
Just because the respondent do not say so, my lord, the requirement which is there, they cannot go take.
It's like this.
Yes.
Yeah, correct. That requirement is there.
Yeah.
But let us say in the case of a digital signature.
My lord.
When you produce a document signed by digital signature,
yes,
that
yes.
is not correct,
Yes.
not true.
Yes.
You don't know how, something like that. That's the
Yes.
burden on the authority to prove it.
The objection is there. I'll come to that, my lord. Before that, may I kindly submit, my lord, one?
Yes.
My lord, by referring to all these case laws, Rup Singh Negi and the Delhi High Court judgment, in fact, my lord would see, my lord, the Delhi High Court judgment refers to another two judgments of the Chennai High Court, Madras High Court, and the Patna High Court, wherein the same stand has been taken, meaning thereby three high courts, at least what I find from the judgment, has come to a finding then that even in a disciplinary proceeding, if there are electronic records, the mandate of 65B has to be complied with. That is what I've understood so far as my understanding goes, my lord. Now, what further I would like to submit, my lord, electronic documents, my lord.
Yes.
Production of electronic documents, my lord. It can be.
Yes.
It can be divided into two parts, my lord. The first prerequisite would be, my lord, by in terms of the Delhi High Court judgment, if it is an electronic record, which is also a document, like I pointed out, my lord, as per the Evidence Act, the first requirement would be that when you exhibit that document, in our case, the videographs, photographs are not even exhibited. That's a different point, my lord. When you exhibit that document, there has to be certificate. That's the first prerequisite. Once the certificate under 65B is there, then again they have to face the rigors of Rup Singh Negi. You give a certificate and say this is the video or this is the photograph. Thereafter, when it is exhibited with the certificate, then again there's the requirement to prove the content of the document, which is the photograph of the videograph, by what has been laid down in Rup Singh Negi, and what is the law in terms of civil and criminal litigation manual. Now, both these things were not done. Admittedly, my lords, there was no certificate. Then when it was produced, the videos and the photographs were not exhibited and they were not proved. Merely tendering of document, that's what Rup Singh Negi says, would not have any evidentiary value. Now, my lords, Lordship comes to page 96. Lordship was asking me with regard to my objection, page 96 of the petition, my lord, that's the further inquiry. I may not have objected in so many words, my lord, but the objection is there, my lord. 3. Shri Digonto Haloi responded as follows.
This is with by saying that they were not part of the earlier.
I'll just read it, my lord. The said photographs and video clips are neither part of the list of documents attached with the charge sheet dated so and so, nor the same way part of the additional documents produced during the inquiry proceedings. More after completion of the whole physical verification, one expert from the so and so made his comment. Thereafter, my lords, I replied to this inquiry report. Lordship would kindly see my reply, my lord. My reply with regard to 99, no? Starts from 99. I'll just come to the relevant portion. Thank you, brother. My lords would find my objection at page 102, the second paragraph onwards, my lord. After that, the respectable inquiry officer, page 102, my lord.
Yeah.
After that, my lord, have it? 102.
After that.
Yes. After that, the respectable inquiry officer reopened the inquiry as per the letter number so and so. Dated so and so, further inquiry was held at NRL Learning Center to exhibit the said video clip only. Finally, the inquiry report against the said further inquiry dated so and so.
This is before the disciplinary authority.
This is before the disciplinary authority against the further inquiry report. Sir, the undersigned begs to state that neither undersigned was present at the. My lords would take note kindly. Third, the undersigned begs to state that neither the undersigned was present at the time of taking photographs and the video clips, nor he had any knowledge about the photographs, video clips, which were taken 5 days after the incident took place, as stated. Now, my lords, this raises doubt, not raises the question of on the authenticity of the videos. And in my humble submission, my lord, the law does not envisage that the delinquent has to object only then those procedures would be followed.
Yeah.
That is not even there. But still, my lord, I have objected, I have shown, my lord. Now, my lord, one more aspect, my lord. I'll conclude my argument, just one more aspect, my lord. I won't trouble your lordship. The written argument is there. I have stated there precisely all the points. Now, if my lords goes through my submissions with regard to each of the charges, it would appear, my lord, it will be proved that there was no misconduct at all, my lord. My lords, I'll just refresh my lord's memory, my lord. If my lords at the same time takes my written argument, my lord, the first charge, my lords, was, my lords, the fire damage cable was kept at the designated scrapyard. That was, in short, that was the first ground, my lord. Now, my lords, with regard to the first charge, the inquiry officer had held, himself he had held that no, Mr. Digonto Haloi was never notified of any designated scrapyard and materials were there in all other places, my lord. So if the materials were there in all other places and I was not communicated, so first charge is not proved. Second, my lords, they say that I have used the word cut and damage cables, my lords, which
that we have already got.
yes, that we have. If my lords consider all the charges and the findings holistically, my lords, no misconduct whatsoever is made up. And in fact, insofar as the two copper cables are concerned, the inquiry officer in his first inquiry has himself stated that in terms of the evidence led by the official evidence, my lord, the general manager has said no, those wires, if they were there, they're old, cramped and scrapped wires. I have given the page numbers, the statements made by all the witnesses. And my lords, lastly, Roop Singh Negi and 64B has to be complied with, and it has not been complied with. And I'll just point out, my lord, humbly, my lord, in Roop Singh Negi, also in Ranjit Kumar Das, which had followed Roop Singh Negi, I produced it on the other day, my lord. In both these cases, when the court came to a finding, that the documents were not proved, they had set aside the entire disciplinary proceeding and reinstated the delinquent employee. In both these cases, Lordship would take note, even in Ranjit Kumar Das and also in Roop Singh Negi. So essentially, my lord, it is not a case, my lord, with the deepest respect, my lord, it is not a case of remand, my lord, because palpably it could not have been done. Now, lastly, my lords, I have not included it in my written argument, my lord. If in any case my lord is not satisfied with the argument, my lord, Lordship would also consider the doctrine of proportionality, my lord. It has already been very harsh on the petitioner, my lord. 2016, he is out of service. He has a daughter, he is a young man, my lord. Lordship would kindly consider that, my lord. And I pray that, my lord, the petitioner may be reinstated as well as the petitioner. That's I'll rest my case.
I'd just like to add one page number. In my petition at page number 109, is that during the second entry, we had raised an objection as regards these CTs by written, and as well as during the inquiry. In fact, that is at page 108 of my.
It's not.
I have. That's submitted, my lord.
You have?
I have. On the last occasion, one synopsis with the date and the grounds and our arguments is submitted, my lord.
Yes.
My written argument is not in the court format. If my lord desires
argument.
Yes. If my lord desires, I'll put it in court format like a post title and all, my lord.
Not necessary.
Not necessary.
Only
The other, my learned friends written
only thing
argument.
you put in the page number. There are no page numbers. You put in the page numbers by hand. Otherwise, in case it breaks away, then we'll have difficulty trying to locate. What is the name of your petitioner?
Pankaj Bora, my lord. And this specific objection regarding the CTs, the DVD, was at page 108 of the inquiry report, and my written objection was at page 109 of the petition.
All right.
Rest of the pages are marked in.
Yes.
My lord, first of all, I would like to take your lordship to the rules, conduct, discipline, and appeal rules for the management staff of the NRM. On last occasion, a query has come. What is the procedure?
Yes.
Rule 6, sub-rule 12. Lordship, internal page is 24.
Rule 6.
Rule 6, sub-rule 12. Internal page 24.
Management.
It's below.
Yes. Yes.
May I just read the rule? Before the close of the case, for and on behalf of the disciplinary authority or the competent authority, the inquiring authority may, in its discretion, allow the presenting officer to produce documents and or witnesses not included in the list of documents and or the list of witnesses communicated with the charge sheet, or may itself call for a new evidence or recall or re-examine any witness. In such a case, the management staff shall be given opportunity to inspect the documentary evidence before it is taken on record or to cross-examine a witness who has been so summoned. So this is the provision by which the the further inquiry, in the further inquiry, the document, the photographs and the videographs were taken into consideration. My friend has cited some judgment, but I don't know in his written argument.
But first, the inquiry was completed, then the report was submitted to the authority.
Yes, that is under, in accordance with the provisions of
621,
621.
That power is exercised, not 612.
So 612 is not perhaps called for. This is not a case of the inquiry officer reopening it just before closure.
But
He has closed it.
it starts before the close of the case.
No, close of the inquiry.
Inquiry.
Case means the case,
Inquiry
So
proceeding.
he has closed it. He submitted it to the disciplinary authority.
Yes.
Disciplinary authority said no, this were not placed.
Yes.
You should place it.
This is that was done under
621.
621.
So he will proceed to hold further inquiry according to provision. What about your punishment?
Yes, my lord. Punishment, my lord. Here it was amended in 2005. I have annexed with the affidavit in opposition. That amended.
Is it a part of this?
Rules? No, it's not in the 95 rules. This is 1995 rule. And the amendment portion. I'm sorry, my lord. Probably that was handed over during the hearing.
Give us one more copy.
Yes, I have.
Just make it that is an amended rule.
Well, page 112 of the affidavit in opposition, they've appended it. Major point. Yes. 112 mil running page. Pankaj Bora matter. Affidavit in opposition.
It doesn't matter. You can give us a copy here.
Yes.
If it is the same set of rules.
Same set, only difference compulsory retirement was included, Melo, as after removal, Melo. Next. Start all of the removal.
I'm handing over to. Documents. Got it? 111. 6 June 2011. Page 112.
It begins with 111,
It starts with 111.
6 June.
Yes, ma'am. 6th of June 2011.
Amended.
And page 112, the major penalties 2G.
Hmm?
Major penalties
Hmm.
G. That is
Major
compulsory.
penalty.
My lord, G. Major penalties G. Compulsory.
Compulsory retirement. No. What is the punishment imposed on him? On them?
Compulsory.
Compulsory retirement.
Compulsory.
Initially removal, my lord, was reduced.
But compulsory retirement does not include pension.
My lord,
My service is not pensionable. NRL employees, they don't receive pension at all.
Okay.
There's some contribution made, what I'm told, it's like PF, contribution from the salary itself. So that's my own.
That you have got it.
No, nothing has been paid. Even my gratuity has been withheld, my lord. They have given a statement, some 7 lakhs was. My lord,
I have annexed along with my written submission.
Yes.
Along with my written submissions, I have annexed the documents which were issued to the petitioners, both the petitioners. If your lordship take up the written submission, page 11.
Yes. Page number.
Page number 11. This is the letter dated 21st of November 2016.
Forfeiture of gratuity.
Forfeiture of gratuity as per section 4 clause 6A of Payment of Gratuity Act, and the provision has been quoted here. The gratuity of an employee whose services has been terminated for any act, willful omission, or negligence causing damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. Now, the hereby a show cause was issued, the last paragraph.
Yes.
Last paragraph says, second last paragraph says, as the above mentioned charge has been proved in the subsequent inquiry, rupees 8 lakhs 2,500, which is the 50% of the loss damage to the company, shall have to be forfeited from your gratuity amount. Since you are eligible for a gratuity amount of rupees 3,99,061, the entire amount shall be forfeited. You are to show cause within 7 days of receipt of this letter, but not later than 5th December 2016, as to why the gratuity amount payable to you should not be forfeited. Now, in response, the similar letter was issued to the other petitioner, Pankaj Boro, page 13.
Notice has been put to challenge. Yes.
And the reply they have given, page 15. After that, page 20, it is the settlement of dues from the NRL. It was received by both the petitioners on 27 December 2016. The headings are given: gratuity. In view of the above, the following amounts are payable to you as final settlement of dues from NRL. Gratuity. Hence, you shall not be paid any gratuity. Employees Provident Fund, you are requested to contact so and so, Assistant Manager FNA, NRL, for completing the formalities in this regard. Encashment of privilege leave. You are eligible for encashment of privilege leave to the extent available in your account, which is 289 days as on 24/1/2016. Hence, an amount of rupees so and so is payable to you. LTA encashment pro rata up to 24/1/2016, that is rupees so and so is payable to your under LTA encashment. Pension under NRL's old defined benefit pension scheme. Total amount payable to you as final settlement is rupees so and so, say 73 lakhs, 7,31,000. The following amounts are due from you against loans taken for other liabilities, furniture on hire, VK, NRL hospital expenses. Total amount due from you, so it's such and such amount. After taking into account the payments to you and the amount due from your shall be paid rupees such and such by NRL as final settlement of the dues. The above payment shall be released shortly. Further, kindly note that above amount does not include amounts payable by you to associated agencies like NRL, like DPS, NRE, CCSL, Kalyani Club, etc. NRL reserves the right to adjust withhold any amount payable to you payable by you to the above mentioned agencies at the time of release of the final payment. Please sign the duplicate of this letter and return the token of acknowledgement.
I'll have to pay my lord 4 lakhs.
Sorry?
I have to pay my lord. I'm not receiving anything. My lord would read, after taking into account the payment, the amount due from you shall have to pay. You have to pay to NRL rupees 4,06,011. So they have forfeited gratuity. There is no pension. Instead, they are claiming money from me. Why, my lord? Because presumably that those two old cramped wires were worth 16 lakhs, my lord, which their own employee, my lord, the general manager, has stated, my lord, they were old cramped wires and they were scrapped. And in their affidavit also they admit that they are used and old.
My lord, only one judgment I am relying upon. I have given 2022 6 SCC 563. My lord, I have given a copy. Umesh, my lord. I am relying on paragraph 16, 17, and 22. Here, my lord, the applicability of Indian Evidence Act.
Sorry, para 60.
16, 17, and 22. May I just hurriedly read out this paragraph? The principles, paragraph 16 I am reading. The principles which govern a disciplinary inquiry are distinct from those which apply to a criminal trial, a prosecution for an offense punishable under the criminal law. The burden lies on the prosecution to establish the ingredients of the offense beyond reasonable doubt. The accused is entitled for a presumption of innocence. The purpose of disciplinary proceeding by an employer is to inquire into the allegation of misconduct by an employee which results in a violation of the service rules governing the relationship of employment. Unlike a criminal prosecution where the charge has to be established beyond reasonable doubt, in a disciplinary proceeding, a charge of misconduct has to be established on a preponderance of probabilities. The rules of evidence which apply to a criminal trial are distinct from those which govern a disciplinary inquiry. The acquittal of the accused in a criminal case does not debar the employer from proceeding in the exercise of disciplinary jurisdiction. In a judgment of a three-judge bench of this court in state of Haryana versus Ratan Singh, V.R. Krishna Iyer, Justice set out the principles which govern disciplinary proceeding as follows. It is well settled that in a disciplinary inquiry, the strict and sophisticated rules of evidence under the Evidence Act 1872 may not apply. All materials which are logically probative for the prudent man as permissible. There is no allergy to hearsay evidence provided it is reasonable nexus and credibility. It is true that the departmental authorities and administrative tribunals must be careful in evaluating such material and should not glibly swallow what is strictly speaking not relevant under the Evidence Act. For this proposition, it is not necessary to cite decisions, not textbook. Although we have taken note taken through case law and other authorities by counsel on both sides, the essence of a judicial approach is objectivity, exclusion of extraneous material or consideration, and observance of rules of natural justice. Of course, fair play is the basis, and if perversity and arbitrariness, bias or surrender, or independence of judgment vitiate the conclusions reached, such findings, even though a domestic tribunal cannot be held good. However, the courts will misdirected themselves, perhaps in insisting the passengers who had come in and go out should be chased and brought before the tribunal before a valid finding could be recorded. The residuum rule to which counsel for the respondent referred, based upon certain passages from the American jurisprudence, does not go to the extent, nor does passage from Halsbury insist on such rigid requirement. The simple point is, was there some evidence or was there no evidence? Not in the sense of technical rules governing regular court proceedings, but in a fair, common sense way, as men of understanding and worldly wisdom will accept. Viewed in this way, sufficiency of evidence in proof of finding of domestic tribunal is beyond scrutiny. Absence of any evidence in support
the
of
bottom line here, what is evidence?
yes, madam. There should be some evidence.
Evidence. What?
Exactly.
Madam.
How do you appreciate this evidence?
Madam.
Not by following the broad principles of evidence.
Madam, that is the
strict principle. Yes, certainly should not apply.
Yes, but apart
But
from
if
the
you have to appreciate evidence,
yes,
then what is the principle of appreciating it?
that is provided. But in this case, what your lordship has seen the inquiry report, those photographs and videographs were shown to them, those delinquents, and it was their view was taken. They have never raised any.
Mentioned, I think last or maybe today morning you said that the rules have.
Yes, I have cited my lord. That
612, my lord.
612.
Is there anything specifically with regard to
No, my lord.
electronic?
No, that is not there. Not, no electronic is there. My lord, and paragraph 2 regarding the exercise of
who is taking this video?
That objection only we took, my lord. We don't even know who took those videos and how it was taken.
NLL authorities have taken those photographs.
Who were the authorities?
I wanted to. Is it a matter of court? Then these kind of auctions are not, you keep it under what you ritual.
Yes, because in this case, what happened, these pictures were taken in presence of the police and as well as the NRL officials.
That is after the seizure.
After the police seized the matter.
After the seizure.
After the seizure.
All right.
Madam, just paragraph 22 regarding the exercise of judicial review. The Honorable Supreme Court has stated that reappreciation of evidence is restricted. May I just read? In the exercise of judicial review, the court does not act as an appellate forum over the findings of the disciplinary authority. The court does not reappreciate the evidence on the basis of which the finding of misconduct has been arrived at the course of the disciplinary inquiry. The court is in exercise of judicial review must restrict its review to determine whether the rules of natural justice have been complied with. The finding of misconduct is based on some evidence. Number 3, the statutory rules governing the conduct of disciplinary inquiry have been observed, and whether the findings of the disciplinary authority suffer from any perversity, the penalty is disproportionate to the person proven misconduct. So these are the 3 parameters, the 5 parameters. My lord, I'm sorry to say, my friend has probably quoted wrong judgment in his written note, 2023 SCC online Delhi 4353. I had during the reception, I have taken a printout.
That was not intentionally, if it is also there. I have provided a copy more didn't that.
No problem, but the citation.
How can it be wrong?
The,
It's not reported. It's not a wrong judgment, my lord. It is reported in SCC.
Sorry.
my lord, he has written 2020.
Naresh Kumar Gandhi, the Delhi High Court.
2023 SCC online Dell 4353. I have not seen 2023 SCC online.
SCC online Dell 4354.
Oh. Anyway, there was some typing error.
4354 minutes. Some mistake with the page number. The typographical error, I'm not in the habit of.
You're supposed to give the page number. Where is that?
My page numbers are noted. I marked it.
Give it to me.
Yes.
That judgment probably.
You are saying that is the wrong side.
Yes, I took out a printout of that judgment, which has been written in the written argument because it was handed over at the first of, but it doesn't tally with, it's wrong. Anyway, this is a typing error, typographical error, but
Well, page number. We have placed the judgment also.
Yes.
Hard copy.
Naresh Kumar.
Naresh Kumar, yes.
You
Gandhi.
already given a copy.
Yes, yes. Well, in the written argument, I have given the citation. In the citation, the page number was not correct. My apologies, not intentional. I've corrected it now, man. And in my lord's copy also, it's not corrected, I'll correct it.
Okay.
My humble submission, that judgment probably is regarding electronic evidence, which is tempered and edited. And in case of tempered and edited electronic evidence,
There is only a limited question I'm asking you. The parameters of judicial review of disciplinary proceedings are well, does not have to be with the strict figures of evidence and procedure and all that. So it has to be on a totality of the circumstance fact to find out whether there is some evidence. Now, when we talk about evidence, what is the manner of appreciating that evidence? Is it a case that evidence act is totally not referred? Because evidence act, even if you refer, there will be rules and procedures to what is an oral evidence, primary, secondary, including 65.
that is correct.
So, with that, whether the court is permitted evidence from that step.
That is
the only question.
In fact, my lord, if we go through the order for further inquiry, as well as the inquiry proceeding, the further inquiry proceeding, it doesn't say that it has taken as an evidence, as those electronic photographs and the videographs were not, as my learned friend also submitted, those are not even exhibited. These were only taken note to reassure that all the charges are proven. If we go through the order,
You are referring to the subsequent inquiry.
Subsequent, because these photographs are taken into consideration in the subsequent further inquiry.
So it is pursuant to the further inquiry finding that the punishments have been imposed.
Yes, in both the first inquiry as well as the further inquiry. This is only for confirmation of so that the management staff cannot say those photographs were not taken into consideration later on. That is why the
first inquiry, the inquiry officers on record say that they were with the presiding officer but not placed.
Yes.
Yes.
Which
That
is
was not
why,
placed.
therefore, there was no question of the inquiry officer taking into account the photograph.
Yes.
It is only pursuant to the disciplinary authority asking them
Yes,
that you
correct.
go for further inquiry in respect of this because it was already
Available in the record.
presenting. I think
That is only perfect.
okay.
Short reply, my lord, one line, the judgment relied by my learned friend, my lord. Those are the general principles with regard to a disciplinary proceeding, but that does not speak about the method and the mode of how the evidence has to be produced, my lord. What correctly fell from my lord. I'm very grateful to my lord, my lord, for a patient hearing, my lord.
Allah is right.
CAV. Yes.
Deeply obliged.
We thought of disposing it off, but
My lord.
huh? 47, 47 we'll list it tomorrow. We'll list it tomorrow. We'll list it tomorrow. 47. We'll list it tomorrow. I think it is better we list it on 19. Yeah, trust it. What can be done now?
What can be done?
You are unable to bring your counterpart. He's not here.
He never comes here. Last time
Huh?
He knows. Actually, what happened? It is not there. Every day when the chief visited that after he cancelled the battle for Taylor, he never come. He never come to it. That's the policy.
That is okay. Then now in view of the ensuing holidays, I think it will not be properly listed tomorrow. It is absent.
That's why, my lord,
We'll have it on 19th.
my lord, our problem is, my lord, deputy commissioner, my lord, requested us to, because the election is declared, my lord, to some
You
extent.
tell that in view of these holidays, it has to be on. It has to be not on 19, 18, 18 reopening.
What problem is because due to this,
You have no problems during Bihu. What are you saying?
He's my lord, he habitually absent, my lord.
We are fixing it on 18. What can be done? You want an order in his absence? He'll come back for review.
His name is shown in the college for schooling also there.
Therefore, we are giving him one more opportunity. Instead of tomorrow, we are having it on 18. 18 is the reopening.
In once and last occasion also, my lord, he was given one opportunity.
It was no matter what 18th. Mr. Yeah, he represents the government, Mr.
That's on behalf of
on behalf of
M.